Hey,
On the last occasion I have mentioned, and your lordship was accepted, but requisition receipt has not gone into. Again, I am reminding that.
what is the urgency?
That is a criminal matter. Criminal matter, that is a 2012 matter. And that was dismissed for default and restored. And your lordship was granted, and he accepted my mentioning, but a requisition has not been given. I again.
So what is the urgency? 2012.
Urgency is this one. You are got already fixed date for a year. Others, I shall be highly patient.
When the lower court date is fixed?
This month.
When which date? Which date the trial court has fixed the date? 25th. Okay, mention on Thursday. I will take the matter.
But yesterday, my lord, your lordship has been pleased to tell us, my lord, to come today.
Yes.
But this matter, my lord, I'm praying for upgradation on the ground, my lord.
Come on Thursday. Come on Thursday.
But yesterday, your lordship told us to.
Yes, Thursday. But I find that if I keep the mentioning every day, then I will not take the matter for hearing. That's why I keep only 2 days. Whatever they mentioning, come on Monday or Thursday. That's all.
But upon notice, I'm mentioning, my lord.
Okay, no problem. Yes, call.
Well, only one indulgence. Yesterday was
holiday. Monday was holiday.
Whatever yesterday taken, Monday was holiday, Tuesday the matter was taken, mentioning matter was taken.
I have been asked to come tomorrow.
Okay, come Thursday, no problem. 1 day is there. Yes, call the list.
Under compelling circumstances,
Nothing.
Mentioning was done. Your lordship
My lord.
specifically directed to appear the matter is to be mentioned. Corrected order is required to be produced before your lordships. Your lordship took up the matter, and my lord.
Corrected order means order is to be corrected.
Yes, no. This, my lord, this point which has already been decided. Your lordship asked my learned junior to correct that order, and it will appear to be mentioned and serve the notice upon the other side. But it was mentioned, it was accepted, notice was served upon the other side, matter directed to appear, they have to be mentioned. It is not appeared.
But list is not here.
Files are here.
The mentioning list was not with my officer, that's why it is not listed. Whatever the list.
That appear tomorrow, then your lordship already directed.
Tell your junior to come tomorrow, I will take.
my lord, this is only for, my lord, extension of interim order, my lord. The interim order,
my lord, regarding my tender matter, my lord. Tender matter, my lord. Tender matter, my lord.
Come tomorrow.
well, this is only for.
My lord, yesterday I was mentioned, my lord. You directed me to
come tomorrow.
mention tomorrow, my lord.
See, Monday and Thursday is fixed. Monday court was not there. Thursday, Tuesday you have taken. Now you come to Thursday. Tomorrow I will take. Monday nothing will happen.
So this is for extension of interim order. Interim order expiring on this Friday, my lord. My lord, way back on my lord 5th, my lord, I mentioned this matter, my lord.
Friday.
Fix this matter on my lord 14th, but it is not appearing the list.
Just a minute.
My lord.
Tomorrow.
My lord, grateful.
Tomorrow fixed as a to be mentioned for extension of interim.
Grateful.
My lord,
Lordship under
yesterday I received the server copy, my lord. My name is not in the.
If you are not given the name, what can be done?
Lordship under compelling circumstances.
My name is on the record. I am the petitioner. My name is on the record. What can be done, Malay?
So the advocate who had argued the matter, who has given the cheat, that has been recorded.
I have argued my.
I have not seen you to argue the matter. How the court can record the name? Yes.
Lordship under
It should be corrected, my lord.
Please allow the other party to mention. Come tomorrow.
Yesterday I have come.
Come tomorrow. Come tomorrow.
Petitioner took the loan from the bank, my lord.
Come tomorrow. All
under compelling circumstances. I'm mentioning
What is
lordship.
the compelling circumstances?
Lordship was pleased to allow the mentioning and fixed it on 13th of January. Today is 14th of January. Yesterday also the list, the item number was item 188 and today is 163. My lord, I am the biological mother, lordship. I am not getting my child back. This is the CWC.
Child?
I am the biological mother, lordship. From the day one, I am claiming back my child, and my child was given for illegal adoption during the pendency of this case. Your lordship was please.
Come tomorrow.
My lord.
Mention tomorrow. I will take the matter.
With my lord's leave, if I may be permitted to mention a matter.
Don't know, sir. You not argue the matter. Whether you are present in the court or not, how your name can be recorded here? I don't know. Let come tomorrow. Yes, call the
With my
list.
lord's leave, if I may be permitted to mention
Call
a
the list. Call
matter.
the list.
Have a look Have a look to the order sheet,
My lord. My lord, 1 to 13.
Yes.
Those are those writ petitions, my lord, which are challenging, my lord, that West Bengal incentive, my lord, scheme, my lord, revocation of 2025.
Yes.
My lord, this has been fixed, my lord. I understand, my lord. The original side matters, my lord, are on the 27th and 29th. These are, my lord, all, my lord, similar issues challenging, my lord, that act.
27?
27 January and 29 January, my lord, has fixed it, my lord, at 3.
Both days 3 p.m.
3 p.m. That's on the original side, my lord. This can, my lord, appear, my lord, along with those matters.
I'm appearing for WPATC.
Only so
In this, in all matters.
whole batch of writ petitions, same issue, my lord. Only one thing, my lord, in item 8, my lord, that, my lord, because they have not filed, my lord, affidavits in the matter, because, my lord, item 8, my lord, I find even in this group, my lord, item 8 is slightly different. My lord, if they want to use an affidavit, my lord, kindly give those directions. They should, my lord, file their affidavits, my lord, before, my lord, that date.
Well, we have to use this. Factually, there are different stories. Factual metric is different in each of them. We have to find. And mother, if I'm not wrong, mother, 9 to 13, subject to correction, there has been no direction to file evidence.
That's why I'm asking whether the affidavit
Yes.
is completed or not. Not completed. You will use the affidavit.
Well, they can. The challenge is the same. If they want to use an affidavit, well, they can. We don't, my lord. I don't think you need to reply or anything like that. Well, they can
And
file it, my lord, before
How
the
soon you will
27th.
file the reply affidavit?
I require 4 weeks.
4 weeks. So, my lord, what will happen is, my lord, the other hearing, my lord, will get, my lord, all, my lord, derailed.
Yes. You are appearing for whom?
WPATC.
And you are for the state. Huh? 4 weeks time, the other matters are fixed on 29, 27 and 29. So what will happen?
All these matters may appear after 4 weeks.
No, your AG has fixed the matter. On the submission of your AG, the matter is fixed. Now, whether you were over the AG, then whether you have taken the instruction from the AG for shifting the matter from 29 to other dates. Have you taken the instruction from the AG?
Let's have it on the 27th, 29th.
Hmm.
You can get their affidavit ready. Let them have it ready.
So how soon you will file? How soon you will file the affidavits? 4 weeks I will not grant. Huh? Today we are on 9, 8. So okay, you file by 30th January. Reply you will file.
My lord, may I? Sorry, my lord. I'm so sorry, my lord. May I submit this, my lord? Kindly, my lord, tag these matters, my lord, with, my lord, the other matter on the 27th. My lord, let them, my lord, try and see if they can file the affidavit by 27th, because the hearing will start. I'm sure, my lord, it won't finish. My lord, it's a, my lord, issue with regard to challenge, my lord, to the violation of, my lord, the act. And then, my lord, if they can file by the 27th, while it is going on, if required, we'll file a reply. Otherwise, my lord, factually, I don't think, my lord, there may not be a necessity to file, my lord, any reply, because it's a challenge to the act. Because, my lord, we can
Okay,
use
that's
this.
what I'm telling that let they file the come on
27th, yes.
27. Let the 27 Mr.
Yes,
Mitra
yes.
start in the WPO.
Yes, and let them
Correct.
file their affidavit by the 27th.
Along
So
with
that's
the,
about
along with the other two matters,
Yes.
let the matter start.
Absolutely.
In the 29, this matter will appear and they will file the affidavit. Then because I don't think the 27, 29 it will be completed.
Correct.
Let
Absolutely.
let the file.
Let them, but
I
let
am
them.
fixing this matter on 29, filing affidavit on opposition by the
27th, we won't be there.
27 is fixed. Let the 27
Yes, yes.
that matter be taken.
We also just wanted to be tagged, Mullah, so that we are also there, Mullah, as part of the hearing.
And this matters I will keep on 29 along
Very
with this.
Very
Because this is the appellate side matter. This is the
Mullah, they can be tagged, Mullah, it doesn't.
That's
Mullah.
right. So
Yes.
let it be come on appellate
Very
side on 29.
Very
And it will continue on 27, 29.
Very
And we'll see to
very
that. The Learned Counsel for the respondents prays for time to file affidavit in opposition. Let affidavit in opposition be filed by 29th of January 2026. List all the matters on 29th of January 2026 under the same heading.
At 3 p.m. kindly put.
No, under the same heading, let it become as a to be mentioned. Let the file. If it will taken up a hearing, then I will shift the matter as hearing matter along with this. Let the file first. Otherwise, it will be difficulty.
Very well,
Because
my lord,
27, 29, let the mitra complete. If it is completed, this will also be taken for hearing on the next date.
very well, very well. 1 to 13, my lord.
1 to 13.
Great.
Give the name. Who are appearing for whom? Give the name. Yes, next.
My lord, my lord, I am the petitioner number 5. I am praying your lordship's leave to appear in person for
Yes, you are appearing for the
self and all others. 6.
who is for the petitioner?
My lord, I am for the petitioner in person and for all other petitioners. My lord, with your lordship's kind leave. My lord, what happened, my lord? Your lordship passed an order on 8th of December appointing one Mr. Sabyasachi Choudhury, learned senior advocate, Bal Library Club, to act as a special officer for holding the election in our housing complex, my lord. But unfortunately, Mr. Sabyasachi Choudhury appeared before your lordship on 11th of December, while I mentioned, and expressed his inability to conduct the proceedings and take the appointment. Now, my lord, one fresh special officer to be appointed by your lordship, my lord, to conduct the election as in terms of your lordship's order. And kindly lordships, one small thing, my lord, so far as the payment is concerned, my lord, if your lordship kindly see your lordship's order.
3 lakhs rupees. Remuneration 3 lakhs.
Yes, my lord, these 3 lakhs we don't have anything. My lord, it is stated that shall be paid by the association. My lord, my humble submission is the association is yet to be formed. It has got no accounts as yet. It's the maiden formation.
Who will pay the who will
My lord,
pay?
the builder is under an obligation. My lord, if your lordship sees the certainly, Mr. If your lordship sees, my lord, the order of the RERA authority I have annexed, my lord, kindly come to page 31, annexure P.
Yes.
At the bottom.
Yes.
RERA order, some people moved the RERA authority for formation of association which was not being formed during last 12, 13 years. Now it was disposed of. After hearing both sides, the authorities of the opinion, process of arbitration has already been completed. The name has been registered, my lord.
Correct.
With the authorities, completed authorities. Construction of addition, etc., etc. The authorities are pleased to give the following directions. Formation of association under the Apartment Ownership Act, which was the main demand of the complainant, has been formed and therefore complaint does not exist. Lord, kindly turn over to next page 32. The respondent promoter shall hand over physical possession, entire assets, project, including assets and liabilities, books of accounts, etc., etc. Now, my lord, in terms of general terms and conditions, money was taken from all the purchasers for formation of association. In terms of general terms.
Who is appearing for the promoter?
Yes. He is appearing.
You are having the
And my lord, one thing. Come on, just a second. My lord, the third party agency which was removed by your lordship and special officer was appointed was also going to be paid by the builder himself.
Yes.
So they are under an obligation.
Okay. Yes.
My lord, I am for the respondent 6. I am also holding the same prayer because of the I'm praying for the same prayer as of my learned.
Yes.
Because the association has not been formed.
It is not accounts.
Yes.
The receipt of mandamus be issued directing the state respondent number 1 and immediately enforce its order in the 7,055 fund the proceedings from by sitting as an intelligence proceedings. But page 49 is the part of which order they have been trying to implement by filing this petition. But page 50 is the milord. Very well portion milord. Here we have the data has order to vote in exchange power under section 116B, one of the principal apartment ownership act based on the observation about the following directional issue. The election of the first board of manager shall be conducted strictly in accordance with mode of decided in the SGF in terms of bylaws.
That's correct. That's correct. I have taken care of all the things. This court find that there is a dispute.
Yes.
That's why a special officer is appointed. Only the Only the question with regard to the election of the association.
Yes.
So election is to be conducted.
Yes.
Correct. So now this court has appointed the special officer, a senior advocate of the bar, but there is a personal difficulty of that he wanted, he will not with some other. So you have any objection with regard to that? No. Then what you want? Yes.
Some facts to be brought into your.
Milord, how can Milord, then it
What? Please don't.
Tell me when are you. Madam, this third party what has forming of association is our job. So we have appointed this issue is not the issue of the SGA. What happened, Milord, in terms of the order passed by the RERA, the election officer who asked both all the residents as well as the third party to be present in the same. And my lord, there are.
That's why there is a dispute on the last occasion. I heard the matter at length and this court. So what? Why you are wasting the time?
I'm only praying, my lord, keep framing a short period, my lord.
So that's why I am. So who will? You are having the accounts.
We are having the accounts with the one of the presiding officer, but all should be paid.
Okay. I am not on that. What will be paid, that is association will decide after the creation of the association. Association will take the resolution with regard to the cost of the remuneration of the special officer who will pay.
Cost of the remuneration should be paid all the parties were equal.
How it can be? The special officer will go behind all of you.
Yes, right, my lord, subject to yours. My lord, the payment of one of the special officer is one of the expenditure, it can be considered as the expenditure of the election.
Correct.
So it should be borne by the participant, that is the residents, as well as the builder, everybody. Because we have already.
Okay.
paid.
Today the court will. Okay. Today court will pass an order. Okay. All the parties should pay 3 lakh rupees. Who will collect and one person will not be given? Who is the responsibility?
That is the main question.
By an order dated 8th of December 2025, this court has appointed Mr. Sabyasachi Chaudhary, the learned senior advocate of the Bar Library Club, as a special officer for conducting the election of the Eden Association of Apartment Owners. Full stop. After passing of the order, Common Learned Mr. Chaudhary has informed this court that he is having some personal difficulties to act as a special officer, and accordingly he prays for appoint some other special officer instead of Mr. Chaudhary. Full stop. Learned counsel for the the petitioner. What is her name? Petition number?
Milord, 5, Mr. Ujjwal.
Petition number?
5.
Petition number 5.
No.
Represented by a learned advocate.
So you are only one. Where is the others?
Milord, I am representing all others.
Where is the authorization?
Milord, that I shall proceed.
So tomorrow the other will come. We will not authorize you to.
Milord, I have affirmed the affidavit for all the behalf.
क्या बोला? The petition number 1, petition number 5 is appearing in person. Submit that he is appearing for all the petitioners and prayed for appointment of some other special officer, and also submit that by an order dated 8th of December 2025, this court has directed to pay the remuneration by the association, but the association has not been constituted. Accordingly, he prays for an order modification of the order for payment of the remuneration by the builder, as the builder is maintaining the account till date. Full stop. The learned counsel appearing for the builder. Learned counsel appearing for the builder raised objection and submits that the builder is cannot be liable to pay any remuneration to the special officer. Consider the submission made by the counsel for the party. This court finds that the petition number 1, petition number 5 is appearing in person, but other petitions not appearing. On the last occasion, the petitions have been represented by an advocate, but today nobody is appearing before this court. The petition number 5 has not placed any authorization from the other petitioner to establish that he has been authorized by the other petitioner to represent them in the instant date application. Accordingly, this court find that at this stage no order can be passed.
Order, then order. Milord, then Milord, kindly take it up tomorrow.
Bring the advocate. The advocate is there. You are appearing in person for one on. There are several petitioners. How the court can be taken up for hearing?
Milord, I have affirmed for.
You bring the advocate, or you bring all the authorization. Even the authorization also even authorization will not suffice.
No objection if it's like.
No, Milord,
Yes, call the other matter.
Milord, then kindly keep it in the list.
You
Milord.
take first instruction, mention this matter. Court will take the matter.
Yes.
That proceed with the election may.
No.
Well, because otherwise.
I cannot pass any order.
Yes.
Yes, call.
Milord, kindly fix the date, Milord. I shall.
Sir, come with an advocate or come with your.
I shall come with an advocate.
So come, then mention. How the matter can be taken on your prayer? Only one petitioner. There are several petitioners.
Milord, I am duly authorized by the others, Milord, and affirmed affidavit for.
Show the authorization.
Milord, the affidavit has been affirmed, Milord. Milord, sir.
Affidavit can be affirmed, appearing before the court to represent. Where is that?
Milord, that I can produce, Milord.
Produce.
In course of the day, Milord.
Call the list. Yes.
19.
Item 19.
Item 19, my lord, we are for the writ petitioners.
Yes.
My lord, this is my lord against the Punjab National Bank. My lord, deals my lord with a fraud
Who is
declaration.
appearing? You are appearing.
Well, as I am appearing for the bank. Well, as I appear.
My lord, this is my lord challenging. My lord, initially, my lord, we challenged a show cause notice under the writ petition. My lord, while the writ petition was pending, my lord, there's been a fraud declaration on the basis of my lord, the RBI circular. My lord, no, in fact, my lord has dealt with my lord similar matters for my lord, the petitioners. My lord, may I just my lord show, because my lord, now the law is my lord, that not only my lord, the documents, my lord, all documents mentioned in the show cause notice, including my lord, underlying documents, all have to be supplied my lord, to the petitioners, my lord, before my lord, they can effectively my lord, deal my lord, with the show cause notice. My lord, that's the law. There are orders my lord, passed my lord, by this honorable court and also by my lord. My lord, this is the last order which my lord had passed. My lord, can you look at it? Oh, it's a full compilation. That's why my lord, there's similar writ petitions, my lord, 19 to 21. This is my lord, the last order, my lord. This is my lord, the first order which was passed. My lord, here, my lord, this is the first order, which my lord had also considered when my lord passed the order, 2nd February 2024. And my lord will find, my lord.
Where is the
Paragraph 64, page 19.
Where is the order declaring fraud?
My lord, that is, my lord, in the supplementary affidavit at, my lord, page 215, volume 2. First week, the supplementary affidavit.
এখানে নাই ওই কি ওটা পেলাম ম্যাটার নেই
Supplementary affidavit. And my lord, in this bunch, my lord has seen my lord's last order, my lord, that's also there, 19th December.
Yes, I understand.
18th. Sorry, 15th. Yes. 15 December.
Yes.
That's the last order which my lord was pleased to pass, my lord. Here also, my lord, what had happened, my lord? Very similar case, my lord, where my lord, it was pending, my lord, will find, my lord, affidavit of service supplementary filed by the petitioner. The last, my lord, 3.
Para 7.
Yes, absolutely. Paras 6, my lord, has set aside, my lord, the
Impugn order.
yes, which is, my lord, also a fraud declaration, my lord. That was 26th November. This is, my lord, 26th December. Find any for paragraph 7, my lord. Absolutely, my lord. That's the paragraph operative.
Yes.
My lord, 19, my lord, is exactly, my lord, similar situation.
ये नहीं सप्लीमेंट्री नहीं है not there. You are having the copy?
Just give copy. Supplementary. It was filed in court. Last day we filed. Court filed. Last day it was filed in court. Mr. Chaudhary was there. Give copy. Supplementary. नहीं last day. हाँ.
Other matters? Any of them?
অন্য কোনো একটা দেখো
সেদিন
নেক্সট ম্যাটার
একবার নেক্সট ম্যাটারে দেখুন তো নেই No, but it was filed in court last week.
The court condition is very pathetic.
System has to live up. Mulad, anyway, Mulad, are very, very hard work. Very, very hard work. Mulad, I see Mulad the sites now. Mulad, it is
Very difficult to. You are not having the copy.
copy.
You are also not having the copy.
I don't know why Mulad these days everything is
So many advocates not.
All soft copies.
All soft
on the iPad.
Give the. You have annexes.
Yes.
Give. No problem.
no. Achha.
That's correct.
The last page 215. Page. One note, sir.
No, no.
Well, this is. আমি এটা দিচ্ছি নামানেরটা
তোমারটা নামানেরটা কত নোট আছে
এটাই নোট নেই
এটা নোট নেই
page 215 not is the
Not kept the note. Yes.
well at page 215 well this is 22nd December 2025 well it scrolls down Mullah.
We have taken cognizance the response of the surplus notice. So this is the impugn order.
Yes.
Where is the show cause notice?
Sorry, Mullah.
Show cause notice?
Yes, Mullah. The show cause notice. Mullah, that's in the writ petition. Mullah, page 361. Volume 2. Writ petition.
Volume 2 আছে?
16th April 2024. Volume 2 আছে না volume 2?
Volume 2
Writ
আছে?
petition. Writ petition.
এই volume 2 নাই?
What is that? Court records nahi.
What has happened to the court record?
hard copy now. Hard copy the volume 2 we have the hard in the entire writ petition entire
It's volume 1, volume 2. How many volumes are there?
Mullah, there are Mullah 8 volumes.
8 volumes.
In fact, Mullah, in the writ petition, when we challenged the show cause notice, we also Mullah enclosed Mullah annexed all the orders which were passed Mullah earlier. Because my lord's order came later. My lord, on similar issue, my lord, when my lord, the
So these are so-called
declaration,
notice.
yes, declaration of fraud, my lord, was settled. Page, my lord, 361, my lord, is the show cause notice.
Yes.
And my lord, we replied, my lord, there are two show cause notices. First, my lord, we replied.
Then we replied asking for document.
So this audit report is of the succession and succession.
My lord, two, my lord, correct. My lord, there's two audit reports, my lord. One, my lord, is the KPMG. One, my lord, is Saxena and Saxena.
KPMG, they are relied upon.
Yes, my lord.
366, they have taken into consideration finding of the report of succession and succession.
My lord, there are
And where
two
is
show cause notice. One was 361.
yes, 361 can now come to the page 366.
At 362, my lord, will find at my lord, the top key findings of the report of
Acha,
KPMG.
yes, KPMG.
And my lord, 366 is my lord Saxena. Then my lord, we
So where is your reply? Where is your reply?
my lord, we replied, my lord, which is my lord in the supplementary affidavit.
Okay.
My lord, after the show cause notice, my lord, we immediately filed a writ. And then, my lord, they gave us, my lord, a personal hearing notice. To that, my lord, we replied, my lord, on 22nd May 2025. The 13th May, again, give me that. My lord, that is, my lord, page 43.
Page 43.
Yes, my lord, my lord, may I just. Yes. Arekta ready করে রাখুন 43 to the just and take out the reply. Forty-three to the this is 43. Take out 53. This is my lord 43. May 2025. This is subsequent, my lord, will find subsequent to a show cause notice dated 16th April, head office committee, such opportunity of hearing. Then my lord goes down, my lord, and sees page. So there are two personal hearing notices, 43 and 40. 46. That's the second one.
No, this is a hearing notice.
Yes, and
where is your reply to the
yes,
so-called?
53.
53.
Same volume, 53. Just
They replied to the first one.
53, will find 22nd May 2025.
Yes.
And at page 66, will find 66. So we give all the entire history is given. At page 56, 14, we say why the reports can't be relied upon. And at page.
No, where you mentioned that the report is not submitted, not supplied to you, and
page 66.
Yes, page 66.
The report and annexures were there, but documents which was relied upon in the report are not with us. Page 66 will not be sought for because that's what their case was. They say, oh, the report and with documents not has been served upon you. Page 66 will be find para 61. Will find I said answered. Then however I'm unable to comment on the specific transactions. Then I require the following document information from you to be able to give an effective and fruitful response. Then it's A, B, C, D, how that's how.
Yes.
And then 66, then again page 72. All the issues we have dealt with.
For each document.
72, again each issue we have asked for the documents. Because my lord will also recall, my lord, we were effectively, my lord, out of the management, my lord, because of the supersession of the board, my lord, and taking over, my lord, by the administrator in October 2021. So without these documents, my lord, because obviously, my lord, most of these loans, my lord, got repaid.
Yes.
Then, my lord, page 72. Then again, my lord, will find, my lord, page 80, paragraph 115.
Yes.
Page 18, light of the issues indicated, once again, humbly request provide me with all the document information on loans furnished by Saint long and such. Provide us the following documents.
The same thing. Yes.
Yes. And then, my lord, also paragraph 122, page 84. And lastly, my lord, paragraph 138, page 88.
Page 89 onwards, Saxena.
And, my lord, from pages 89 to 97, my lord, with regard to, my lord, Saxena. My lord, will find, my lord, paragraph B there at page 89. Paragraph B onwards, my lord, will find.
Yes.
Now, my lord, they came back and say, oh, we have given you the forensic audit report and the documents. Sorry, not the documents, but the forensic audit report.
Got it.
And this is, I must also show, my lord, for sake of completeness, this is, my lord, what they say at, my lord, page 40. Sorry, my lord, this symbol. Page 46, my lord, will find. That was, my lord, what I showed.
Page
my lord,
46 of RIT.
of the same, my lord, that iPad, my lord.
Now got that.
Oh, okay.
46, yes.
Thank you. কোথায় ছিল officer?
These are personal hearing notice.
Second.
46 is the personal hearing notice.
Yes. Mullah, that's the second. Yes, Mullah, the second one. And here, Mullah, it says, I just wanted to show that we are also sharing the forensic audit report. That is, Mullah, important. Page 46 and 47, Mullah, will find. So this is, Mullah, what they say. The documents, Mullah, underlying documents are not shared, and that is what was required.
Please note that.
Because our case was, Mullah, that if I was in management, yes, FAR would have been enough, but not now. If I have to defend myself.
So we are also sharing the forensic audit.
Yes.
So your case is that though you received the report, but the forensic report, but not document.
Yes, correct. Because that's what, Mullah, the order of, Mullah, the first order of second, Mullah, February 2024 said, and even my lord's order also said that. It has to be, Mullah, a meaningful response. How you came to that finding in the forensic audit report, and on the basis of that, you came to another finding of, because what has happened, my lord, and this is, my lord, very serious, because what in this matter, what Punjab National Bank did, my lord, they passed that order, my lord, on the 19th. On 19th, order is dated, my lord, 19 December. They, my lord, communicated to us by a letter of, my lord, 22nd, which was received by us on the 26th. And in the meantime, before, my lord, communicating also, they had, my lord, let, my lord, everyone else know. The newspapers, stock exchanges, that also, my lord, I put, my lord, in the supplementary affidavit.
Where is the final order? Acha, that one.
Yes, my lord, that is the final order, my lord, was at page 215. Yes.
Yes. Anything further?
No, my lord, on the basis of, my lord, these issues, my lord, are already covered by my lord's order as well as, my lord, the earlier orders. We also have, my lord, a Bombay High Court division bench, my lord, wants to look at it very similar. What my lord has held, very similar principle, my lord, relying on a Supreme Court decision saying that for it to be meaningful, you have to give all underlying documents.
Ambani matter that.
No, my lord, this is, my lord, Milind Patel. This is, my lord, a division bench. If my lord wants to, my lord, yes, my lord, kindly have a look.
Which date? What is the date of the judgment?
My lord, this is, my lord, a 2024, March 4, 2024.
No, 25, I think some.
Oh, there's another, my lord, we haven't.
You might be Mr.
Oh,
Mr. Diwan, you are having the Bombay High Court judgment.
Yes, my lord, that's on the forensic audit report. My lord, is correct, absolutely correct. They are absolutely correct. That was also, my lord, set aside. The whole, my lord, audit, their, my lord, report itself was set aside.
Correct, that's
correct.
Yes.
Yes, correct. Now, my lord, yes, my lords.
This judgment, my lord, may I just hand over, my lord, 2024. 2024 251 company cases, page 1. At paragraph, my lord, 24 onwards, my lord, will find. It refers to, my lord, the Takano case, my lord, of the Supreme Court. And, my lord, will find, my lord, 24, it says duty to disclose investigation material. Well, the respondent submitted only materials that have been relied on the board needs to be disclosed. The appellant have contended all relevant materials need to be disclosed while trying to answer the issue. If there's multitude other equally important issues. Then, my lord, at paragraph 25 and 26, my lord, is, my lord, where, my lord, the division bench draws, my lord, its conclusions. We will find, my lord, 25. Need to, the last 3 lines of paragraph 25, including need to provide the underlying materials that are inherent and implicit in the process stipulated under Master Circular. Materials information question for disclosure to the notice. Notice
Yes.
about all relevant material, not just information relied upon referred to in the show cause notice. Not only 26, not only must information that is referred to and relied on the show cause be supplied, but also information that may undermine the allegations contained in the show cause notice, which may therefore not be referred to or relied on, must be supplied only to ensure that everything relevant to arrive at the truth is available to both parties. Objective of the proceedings initiated by issuance of a show cause notice not to somehow find the notice guilty of willful default on the same terms as alleged. Instead, the objective is to arrive at the truth as to whether or not an individual in question is to be subject to penal, which among India's words, consequences. And therefore, if the bank has conducted a forensic investigation of alleged diversion and siphoning of funds and specific roles played by specific individuals brought out in the investigation, such a probe would point to plausible interpretation that certain individuals did not play any role in the diversion and siphoning the materials underlying such plausible interference would undermine the allegation. Therefore, fair and transparent, symmetrical access to information as stipulated by the Honorable Supreme Court in Takano would mean providing access to not only incriminating materials, but also kindly similar exculpatory material.
Correct.
Because it's not only what you have to indict me, but also what is there to really, yes, for me to be exonerated.
Whatever the document.
Correct.
Because might be in your favor.
Yes, correct.
Might be in your favor.
Absolutely. Because that's why, my lord, I asked for, my lord, all details where, my lord, the loans have been repaid, because loans have been repaid. Since
Yes.
all such information relevant for arriving at the truth, therefore, access to the record is a vital element of compliance principle of national justice. Not only has no material supply, also Union Bank has actually ascertained no that was not required to provide material whatsoever, and that is for the notice to prove his innocence. So here, Mullah, just by saying that I've given you the forensic audit is not enough. Because all underlying documents, because based on that, you are again coming to a conclusion.
Yes.
So, Mullah, I submit, and Mullah, just one thing, Mullah, this is, it's in the sense, Mullah, prejudicial, so far as we are concerned. Mullah, they have put everything, Mullah, in the public domain, knowing, Mullah, is a page 292. Mullah, 20. 207, my lord, of that supplementary affidavit, volume 2. So all this, my lord, perhaps 2789. I'm just saying, my lord, before it reaches me, they have ensured that, my lord, at least, my lord, my image, my lord, is publicly, my lord, tarnished. And the matter has been pending, and, my lord, that is, my lord, what we had said, my lord, we challenged the show cause notice itself. My lord, all these, my lord, matters, 19, my lord, is the one, my lord, which I argued. My lord, the other ones, my lord, at the stage, my lord, where, my lord, the show cause notice is, my lord, there. I think 19, Amata 19, 2021. 2021, 22, my lord, at the stage of, my lord, show cause notice. Only 19, my lord, they have already, my lord, the declaration of fraud has come.
Only 19, the final order is.
Yes, yes. Which is similar to, my lord, the situation which, my lord, was pleased to pass an order in, my lord, the Nabard case. That's, my lord, the 15 December, my lord, which, my lord, order, my lord, which I have already, my lord, given to my lord. In the bunch, it is also, my lord, wants to make a note, my lord, it's also in the supplementary affidavit, my lord, we have disclosed. Page, my lord, 303.
What the earlier court has, earlier round of litigation, what was the?
Same, my lord, same issue. Same issue. What happened, my lord, several banks, my lord, pounced upon, my lord, these, my lord, 2 forensic audit reports. And, my lord, went on, my lord, against me. Now, my lord, all these matters, my lord, the orders of which I have given, all involve, my lord, the same forensic report, the same petitioners, my lord, and the same issue.
Okay.
Because they're all in the same consortium of banks. And there, my lord, 303, my lord, will find, which my lord has already looked at.
That's my order.
Yes, my lord's order, where my lord also considered this, and my lord has, my lord, at paragraph 5, my lord, set aside, my lord, the impugned, my lord, declaration, my lord, itself.
Okay.
My lord, I was praying, my lord, for similar orders, my lord, in this matter. Because, my lord, the audit reports are anyway under challenge.
Other matters only show cause was issued. Show cause issued.
Yes.
You have given the reply. You have submitted the reply.
No, my lord, they all challenged, my lord. In some of them, no. This one, my lord, we submitted. The show cause notice came, we filed the writ petition, then, my lord, they gave a person hearing. We, my lord, gave a notice, my lord, asking, my lord, for all those documents. They said we are supplying the forensic audit report, and, my lord, they went ahead, my lord, and declared us, my lord, as fault.
Okay. That's all?
Yes, my lord, those are my submissions.
Yes.
Yes, my lords. Now, my lords, there are 4 matters on your lordship's board. Item 19 to 22. Each of them concerns a separate bank. The facts in each of them, which I'll just shortly.
Yes. Yes. The technology says you have to appear before this court in person.
That's different. That's different. Yes, that's different. Correct. All these orders are passed on that basis.
Yeah.
Well, are your lordships able to hear me?
Yes.
Well, I'm so sorry. My office lost internet. I'm so deeply apologetic. Yes. Now, my lord, I was only saying, your lordship has 4 different writ petitions against 4 different banks, which are items 19 to 22. The facts in each of them are different, which I'll shortly show. Kindly take up the writ petitions one by one. That's important. The first matter which was argued was, my lords, WPA 13,100 of 2024, which is the writ against Punjab National Bank. That's item number 19.
Yes.
Now, my lords, your lordships will first take, my lords, a few key dates in this matter. The show cause notice in this matter is dated 16th of April 2024.
Show cause notice?
is dated 16th of April 2024.
Yes.
The writ petition was filed on 3rd of May 2024.
Yes.
The response to the show cause notice comes an year later on 22nd of May 2025.
What is the date? Reply of the so cause notice?
22nd of May 2025.
Yes.
And my lords, this comes, your lordship will note, this comes when we give them a personal hearing notice on 13th of May 2025.
After
So
personal
there,
hearing.
yes, so therefore, there is no response to the show cause notice given by the petitioner initially.
Correct.
Once we give them a personal hearing notice in the month of May 25, they come out with a response.
Yes.
And the response, of course, your lordships have been shown, seeks documents as well.
Yes.
Because ultimately, we give them one more notice, the second notice on 22nd of October 2025. Because they refuse to come for a personal hearing.
Dated,
This
what is the date? Second.
22nd of October 2025.
Yes.
And ultimately, the fraud declaration order comes on 19th of December 2025.
Yes.
Now, my lords, your lordships has seen the first date, the date of show cause being 16th of April 2024. Your
Correct.
lordship has marked that date.
Yes.
Now, my lords, prior to this show cause, there was already a judgment of this honorable court, my lords, in which writ petitions against 3 different banks had been disposed of by this honorable court. That's the judgment of Justice Sabyasachi Bhattacharya. May I, my lords, just point that out for a second? Because that's at volume 4, page number 933. Kindly have a look at that because that has an impact on this case.
Volume 4.
लॉगिन कर लिया फिर से ये जा रहा है यार.
Give.
इसमें लॉगिन कर.
Yes. Volume 4, page number.
Yes, because I'm sorry, today my internet is giving me trouble.
Yes.
Yes, it usually doesn't happen, but I'm sorry. There's some problem today. Yes. Now, my lords, I was only showing your lordships, my lords, the judgment of this court in this matter. Yes, because would your lordship, first look at the array of parties at page number 933. And your lordships will see these are 3 writ petitions against 3 separate banks. Bank of India.
933.
Yes, my lords, that's where the judgment starts.
Yes.
So your lordship, my lord, sees Bank of India, Union Bank of India, and Bank of Baroda.
Yes.
And then there is Small Industries Development Bank of India. And your lordship will now come to 935, paragraph number 6.
Yes.
Thereafter, it says thereafter BOI, BOB, and UBI, placing reliance on the same FAR authored by KPMG, issued show cause notices afresh for declaration of the borrower companies as fraud, serving copies thereof on the petitioner in the capacity of promoter director of the said companies. And paragraph 7, petitioner has challenged the 3 show cause notices issued by the said in WPA, etc. I'm not reading all of that, but the subject matter of the writ petition or the writ petitions was 3 show cause notices issued by 3 banks, which is exactly the case in our case. PNB has also issued a show cause notice. Now, Manoj, your lordship will see many arguments were taken before the court, including the argument that necessary documents were not supplied.
Correct.
And the court, Manoj, has dealt with that. Kindly just, Manoj, look at paragraph number 42 and 43 at page number 945.
Yes.
Manoj, may I read 42?
Yes.
This FAR, it is to be noted, is merely a trigger for the formation of preliminary opinion by the respondent banks in order to issue a show cause notice. Thus, at the stage of show cause, not required to enter into the probative value of the FAR. Such probative value and evidentiary strength of the FAR can only be ascertained at the stage of final decision. And now look at 43. Other aspect of the challenge taken out by the petitioner is that the documents relied on in the FAR have not been served. However, the FAR has only been cited only as a basis of the show cause notice, and it would be impracticable if the respondent banks are directed at the show cause stage to serve on the petitioner the entire voluminous records which would substantiate the allegations against the petitioner. Records taken together may cover the relevant accounts, transactions over years, which would run into thousands of pages. At the same time, balance has to be struck between the interest of the petitioner and the principles of natural justice to ensure that an effective opportunity of rebutting the allegations is given to the petitioner. Now, let us kindly now take paragraph number 53. Which is, Malas, at page 948.
Yes.
The court says, thus a balance has to be struck between the limit up to which technicalities should be adhered to on the one hand and speed in reporting is ensured on the other. In fact, throughout the master direction, stress has been laid on the pace of reporting in order to protect the banking system from fraudsters. 3.3 of the master directions deals with delays in reporting of frauds and mandates the banks to ensure reporting system is suitably streamlined so that delays in reporting in frauds are avoided. Banks are to fix staff accountability for delays, etc. Now kindly omit 54. Just look at the conclusion 55 at page 949. Thus, time is the essence of the entire master directions, which lends an extremely summary character to the process involved therein. So, and Milos, this, your lordships will see, this is the main thrust of the judgment, that time has to be, the time is of the essence. Please see page 950, paragraph 59. Next page.
Yes.
Thus, looking into the entire tenor of the master directions, it is evident that unnecessary reliance on formalities would tend to defeat and frustrate the very purpose of enunciation of the said directions. Hence, what is to be ensured is that specific instances of allegations are to be mentioned in the show cause notice, although all particular documents which are to be relied upon or intricate details of the fraud need not be given at the show cause notice. Show cause notice is a mere indicator of the allegations made against the borrower. It is to ensure that an effective opportunity of hearing is given to the accused. Now, in this week, the court had issued certain directions, which will start at page 951, paragraph 64 onwards.
Yes, 7 directions. Yes.
Yes. Para 64 says, first, show cause notice, enumerating the exact offences alleged against the director. If any FAR or other document forms the basis of the show cause, same is to be served along with the show cause notice. And please see in bracket, both the said criteria have in fact been satisfied in the present case in respect of BOI, BOB and UBL because the forensic audit report had been given to them undisputedly. Now let's kindly see 65. I'm relying on 65. A fortnight thereafter is very important. Fortnight thereafter would be ample time to give reply to the show cause notice. In its reply, noticee shall, apart from addressing the allegations and controverting those specifically, specify the documents which are required to be provided to the noticee by the bank's financial institutions. If necessary in the reply, they can reserve their rights to give a further additional reply upon receiving such documents. 66. Within a week from receiving replies, banks can give an inspection of documents if extremely voluminous and or furnish copies of particular documents. 67. Within a further fortnight, the noticee borrower can be given an opportunity to file additional reply in light of the documents which have now been inspected served on them. I will stop there now. Now, let's kindly note my first ground is that the show cause is 16th of April 2024.
Yes.
The first time they give a response and the first time they ask for documents is 1 year and 1 month later on 22nd of May 2025.
Yes.
So two elements stand breached here. One, the previous order of this bench which had said that if you receive a show cause notice, within a fortnight you have to give a response asking for documents.
Correct.
Now that was breached, point number one. The second point is, if your lordship, my lords, looks as the show cause notice itself, which is, my lords, volume 2, page number 361. And the relevant is 366. Paragraph 4 of the show cause notice, your lordship will find at page number 366, says you are hereby called upon to show cause and make submissions in writing within 15 days from the date of receipt of the letter. And the response comes not in 15 days, after 1 year and 1 month. And your lordship will also note the 15-day requirement is a statutory requirement under the RBI master directions. So this 15 days is not coming because the bank is saying, the master direction says so. So my first point is that the petitioner which has failed to give a response to the show cause notice within the necessary time period and has asked for documents much later is disentitled to any relief at the interim stage. That's my first point. Well, my second point is that much was said about this requirement of documents to give an effective response. Your lordship will first make a note of the fact that undisputedly, both the FARs, which is the KPMG FAR and the Saxena FAR, along with their annexures, all annexures there too, have already been supplied. So their case is, kindly note, is not that I have not been given the full I have not been given the full FAR or the documents accompanying the FAR. Their case is not that. Their case is that apart from what you have already given me, I need something more to respond to the SCN. That's the case. Now, my lords, kindly, now this is important. Your lordship now, my lords, will contrast volume 2 of the writ petition, which has the SCN, along with, my lords, the requisition for documents. So, my lords, kindly now, my lords, for instance, and I want to satisfy lordship's conscience on this aspect, kindly take, my lords, page 362 and simultaneously 362 of the writ petition volume 2. And my lords, along with this, my lords, kindly keep the response of Mr. Hemant Kanoria, petition number 1, which is in the supplementary affidavit, page 53, side by side.
Yes.
Now, my lords, may I, because I want to show to your lordships what kind of documents are being asked. Now, your lordship will, my lords, first look at 362. May I just tell your lordship what the allegation at page 362 is?
Yes.
Now, may I read 362? Allegation number 1. There are 7 counts of allegation. I'm only reading the first one now. Key findings of the report, lordship will see from the table. Key findings of the report of KPMG Assurance and Consulting. Now, number one, loan to customers with very weak credit profile and where probability of default is very high. Credit exposure was found towards customers who by SREI entities internal credit rating process constituted default, which is SREI 10, very weak, SREI 9 and poor credit quality, SREI 8 categories. Outstanding value of such loans is approximately 8,657 crores, constituting 44.6% of sample contracts reviewed. Some of the instances are depicted below. EMTA Coal Limited, categorized as default category, was extended loan of 274.32 crores. Nurit Properties, connected through shareholders associated with EMTA, was disbursed 958 crores, despite the fact that Nurit was categorized as SREI 9. SREI 8 rating, which indicates poor credit quality accounts, have been outstanding exposure of 1155 crores, out of which connected entities, Solapur Tollways and Ghaziabad so-and-so, have also been given loans. So, Mullah, the allegation is quite clear. The allegation is that there are certain entities with very, very poor credit rating, and you have given loan to them. Now, please see the documents they have asked. Now, since your lordships are contrasting this, please contrast this with page number 66.
Yes.
Now, Mullah, para 61 is the requisition for documents to meet the first allegation. I'm showing the list of what documents they have asked. May I read this now? Because I am 61, I'm just the last line of 61. In light of the issues indicated above, I require the following documents and information from you to be able to give an effective and fruitful response. Please mark those words. And now, what are these documents? A, names and details of all officials of your bank who are involved in granting the subject loans to SREI entities. They need the names of my bank officials. The allegation is you have given the loan. Now look at B. Names and details of all officials of your bank who were monitoring the manner in which your loans to SREI entities were being utilized in respect of loan accounts mentioned in paragraph 1 of the HCNs and section 6 and 7 of the KPMG FAR, etc. C. Names and details of all officials of your bank who were scrutinizing the loan account mentioned in paragraph 1. D. Copies of all appraisal reports prepared by the bank officials in respect of the loan accounts mentioned in paragraph 1. Then E. Copies of all minutes of meetings of your competent credit committee special cell relevant competent authority where the appraisal reports prepared by your bank in respect of loan accounts mentioned paragraph 1, etc. was considered. Copies of minutes of all meetings held in your bank by your competent authorities where all loan accounts and loan proposals of SREI entities were placed and discussed. Copies of detailed appraisal report and credit assessment memo prepared by relationship managers and regional heads of SREI entities of the transactions. Copies of notes reports prepared by relationship manager and regional heads with respect to transactions mentioned in paragraph 1. Minutes of meeting of the credit committee dealing with the approval, etc. disbursed and detailed. Copies of internal audit reports prepared by auditors of SREI. K. Specific information on the security, present value, also whether the loans are being serviced, restructured by present management. Alleged connected entities, alleged related parties, allegedly potentially related parties. M. Copies of legal opinions obtained by SREI entities, internal audit reports, external audit reports, and carried out from time to time on the issue of related party entities and family members. According to me, not one of these documents is relevant to answer the charge. What Mullahs is being done in this matter by someone who is accused of fraud of thousands of crores is that they don't want a final order to come. So their intent is rake up the issue of natural justice and Mullahs don't let anything happen. I asked myself, your lordship has seen the allegation in the show cause notice. The allegation is plain and simple. The allegation is that SREI has given loans to 3 entities which had poor credit rating. To answer that charge, what they are asking me is give details of my bank. How is that relevant at all?
Yes.
Now, Mullahs, kindly now turn to the next show, allegation by allegation. In fact, Mullahs, just by illustration, I'm picking up one more allegation, allegation number 4. Kindly go back to volume 2 of the writ petition.
Yes.
And Mullahs, kindly now just take page 364.
Yes.
Because this is a one paragraph allegation. Your lordship will just find at page 364, one paragraph allegation.
Which one? Potential diversion?
Yes, yes, potential diversion. Property was purchased by an entity owned 90% by promoter group, Royal Infrasoft Private Limited, held 90% by promoters and 10% by SFIL instead of SFIL, who had first entered into an agreement to buy, but subsequently assigned its rights to RIPL. Purchase was almost fully funded by SREI entities by giving an interest-free security deposit of rupees 117.24 crore to this entity, and then SFIL took the same property on lease from RIPL. This is prima facie case of potential diversion of assets from SFIL to a private concern or promoters. Very simple allegation. The FAR is there and documents accompanying the FAR are there. Now let us look at the list of documents that they want to answer this. Kindly go back, my lords, to the supplementary affidavit, volume 1. And for these, my lords, for this, your lordship will find the relevant page, my lords, where these documents are there is just 1 second. I'll just point this out. Because this is at page number because this is at page number 80 of the supplementary affidavit.
Yes.
Yes. No, Malas, I'm so sorry. I think it's at page number 88. I'm so sorry. I should. It's page number 88. 88.
88.
Yes, Malas, 88. I'm sorry.
Correct. Because they are referring the 88 only.
Yes, yes. I'm so sorry, Malas. Page 88. Now, paragraph 138 is the list of documents.
Yes.
Now, Malas, may I read 138? Again, what? Now, Malas, kindly see. Now, they have given some response in the earlier paragraphs. Now, the documents they need. Paragraph 138. Malas, may I read A?
Yes, yes. Continue.
Names and details of all officials of your bank who were involved in granting the subject loans to SREI entities. Names and details of all officials of your bank who were monitoring the manner in which loans to SREI entities were being utilized. Names and details of all officials of your bank who were scrutinizing the loan accounts mentioned in paragraph 5 of the SCN. Copies of all appraisal reports prepared by bank officials in respect of loan account mentioned in paragraph 5 of the SCNs in section 6 and 7. Copies of all minutes of meetings of your competent credit committee, special cell, relevant authorities. Copies of minutes of all meetings held in your bank by your competent authorities, where all loan accounts and loan properties, etc. were done. Copies of detailed appraisal note, credit assessment memo prepared by relationship manager. Copies of notes, reports, memos prepared by relationship manager. And Malos, it goes on, similar to the requisition made earlier. So one striking feature of this case is that the same list of documents have been sought in this under various heads, and none of them have any bearing on the allegation which is sought to be answered.
Yes.
Because I can understand if one person comes to the court and he says that there is a violation of principles of natural justice because I have not been given an effective opportunity to make a response. I can understand the allegation. But then the onus is on that person to show that this document, if provided to me, I would have responded to the allegation in a certain way. You can't make the argument in an empty way. You have not shown the relevance of any of the documents, but simply said, give me a stay on the fraud declaration because I asked for documents and the documents were not given to me. Now that's point number 2.
Actually, I'm sorry. Actually, I'm just interrupting. Issue 4 is page 84, actually.
Okay, 84. I'm sorry. Maybe
84. 88 is not.
Yes, I'm grateful for that correction.
Actually,
I'm grateful for the yes, I'm grateful for the correction. Let's look at 84.
My learned friend just reads before also a little bit because that explains why we need the documents. I mean.
Yes, yes. Now, Malos, may I do that? I'm sorry. Look at 83. Start from 83. Page 83.
Yes.
Page 83 bottom is the response to issue number 4.
Yes. Issue
now,
4.
Yes. So they give Malots some response, and the list of documents is at page 122. Sorry, para 122, page 84. I'm sorry, I stand corrected. Look at 122 A, B, C, D, E, F, G. A to G are common. 122 A to G are the ones which were sought even in the first allegation and were also sought in paragraph number 88, which I had read. All of these documents don't concern SREI, they concern the bank.
Yes.
And now, Mullahs, now look at Mullahs, the other ones also. H. Copies of notes, reports, memos prepared by relationship managers and regional heads of the SREI entities with respect to transactions mentioned in paragraph 4. Now, let me just pause here for a moment. This is your company. This was under your management. You should be saying, or you should know, whether there was any note, report, memo prepared by your relationship manager. How does a bank know about it? Please look at H. Copies of notes, reports, memos prepared by relationship managers and regional heads of SREI entities. Well, how is the bank supposed to know all of this? It is your company. Look at I. Copies of minutes of the meeting of credit committee dealing with approval, modification, appraisal of loans which were disbursed in details. Again, this is your document. How is the bank supposed to know this document? In fact, our allegation is that you did not do this, therefore leading to a default. Copies of internal audit reports prepared by auditors of SREI entities. Your lordship knows internal audit reports of a company are never shared with bankers. Banks never have this document, but yet they are asking for this document from the banks. Specific information as to security, present value, loans are being serviced, restructured by present management of SREI entities in respect of companies irrelevant. Whether the loans are being serviced or not does not matter to the allegation that there is a potential diversion or siphoning of funds. An account may be perfectly regular, being serviced, but does not mean that there is no fraud. So anyhow, so my second point is, my lords, that documents without showing their relevant and necessity, you cannot have a case for a stay without demonstrating how the documents sought are relevant to answer the allegation made against you. I have only shown two allegations, allegation number 1 and allegation number 4, but your lordship will take it from me, I say so with responsibility. The same list is there in respect of other allegations as well. None of the documents are relevant. Now, point number 3, your lordships were shown and cited your lordship's own order in the case of NABARD and said that order will also apply in this case. Kindly just have a look at the NABARD order, volume 2 of the supplementary affidavit. And that's at page number 303.
Yes.
Now, my lords, now your lordship will now first look at paragraph number 3 of this order at the bottom of the page 303. Learned counsel for the petitioners submit that on 3rd September 25, please mark that date, respondent authority issued the show cause notice upon the petitioners, directing the petitioners to submit written representation to show cause as to why the account of the petitioners shall not be declared as fraud. On receipt of the show cause notice, petitioners submitted reply on mark the date 22nd September 25, which is in a matter of 22 days. Ours is the case of 1 year, one month. Here, objection was taken in 22 days. Now, please see the nature of objection, wherein the petitioners have requested the respondent authority, unless and until the copies of transaction audit report mentioned in the show cause notice, along with each and every information, documented information, which is referred to in the said transaction audit report, is not served to the petitioners, not possible for the petitioners to respond to the allegations contained in the SCN. On receipt of reply, respondent has passed the impugned order on 26 November. This court finds that in the reply, petitioners have categorically stated that unless and until the copies of the transaction audit report mentioned in the SCN as well as each and every document information is not served, impossible for the petitioners to respond to the same. But instead of supplying the said documents, respondent has passed the impugned order. Court finds that respondent has passed the impugned order without supplying the documents on the basis of which the impugned order is passed. Petitioners could not get an opportunity to deal with the said documents, and accordingly, my lords, the order was stayed. Look at paragraph 7. Respondent is directed to supply the transaction audit report. In our case, we are not concerned with the transaction audit report, but a forensic audit report, copy of which with all annexures is already with them. And your lordships perhaps will make a note of this fact. The show cause, as I said, I'm repeating myself, is 16th of April 24.
Yes, I have taken note of it. Yes. Carry
No,
on.
no, I was only pointing out one fact. In December 23, they had filed a suit challenging the FAR. There is a civil suit filed in December 23 where they annexed the entire copy of the FAR. So FAR has always been with them with the documents. Both Saxena and KPMG FAR with all documents has been with them. The NABARD was a case where the underlying audit report, which was not the forensic audit report, but the transaction audit report was not with the petitioner. So he said, give me a copy of the transaction audit report. That's very different from our case. So in light of this, my respectful submission insofar as PNB's case is concerned, I'll come to the other three. In PNB's concerned, this is not, in my respectful submission, a fit case for any ad interim order to be passed. Given the delay, given the fact that they have not explained the relevancy of the documents, we will file our reply to the writ petition. Your lordship will ultimately consider whether in any manner whatsoever the petitioner has been debilitated or incapacitated from effectively meeting the allegation without supply of documents. The fraud order in this case is a very, very detailed order. Your lordship perhaps has not seen the whole order. It actually deals with every allegation, and at the end of every allegation, there is a response. That's all that I have to say in the first matter, and I will deal with the other three after the rejoinder by a learned senior. Because those three are different matters. Those,
So,
in fact,
so this is only with regard to the item number 19, first matter.
Correct. Correct.
You
Yes.
are to the item number 19, the first
Yes.
matter.
Yes.
Okay.
And the others I can deal with now or later, as your lordship says.
Yes.
Lord, I'm really not, with great respect to my learned friend, Lord, I have not understood, my Lord, why these arguments were made again now, because the same arguments have been made before. And my Lord, my learned friend referred to, my Lord, that the first order of 2nd February 2024. Can you, my Lord, come back to that order? And my Lord, there's certain paragraphs, my Lord, perhaps, my Lord, where missed, if my Lord kindly comes to paragraph 61, that is at my Lord, page 933 was showing, my Lord, internal page 18. Do you have a copy of the thing?
Yes, 933.
Yes. My Lord, at paragraph 61 at 950.
Yes.
Although the process of fraud declaration summary under the master directions, the principles of natural justice have to be read into it as much as possible, since those principles are the basic features of rule of law and cannot be short-shifted. Then, my Lord, kindly come to paragraph 67, which he already read, but not the last line, which, my Lord, I think, my Lord, is very important. Paragraph 67. Page 951, it starts, within a further fortnight, if necessary, the notice borrower can be given opportunity to file additional reply in the light of the documents which have now been inspected, served on them. This happens, my Lord, after he serves the show cause notice, after he gives the document. If you ask for more documents, then, my Lord, they have to give it to us. And then we replied, then it says, thereafter a hearing shall be fixed.
Within a week of receiving this reply,
Yes, fixed by the bank on the basis of the reply.
Inspection of the document,
Yes.
if extremely voluminous, or furnish copies of the particular document which are sought to by the borrower.
Correct.
Within a further fortnight, so timeline is fixed.
And thereafter a hearing shall be fixed by the bank on the basis of the reply.
Correct.
Then upon such hearing being concluded, decision will be taken whether or not to declare the borrower company or its director of fraud or perpetrator of fraud. A foresaid procedure would be taken. At least, well, these timelines are late. I will just comment on the timeline immediately. Then, Malad will also come to paragraph 74. Such are disposed of.
Correct.
By directing the petition, each of these writ petitions to furnish his reply to the show cause notice within a fortnight from date, indicating the documents which are required to be inspected by and furnished to the petitioner to effectively rebut the allegation made therein. Upon such reply being given, respondent bank in each of the petition should fix a date for inspection documents, extremely voluminous. Alternatively, the bank shall furnish copies of relevant documents petitioner for the fortnight thereafter. Upon being so served, given inspection 76, petitioner shall, if necessary, give an additional reply in the light of such documents. Such additional reply shall be given in outer limits and such. Respective bank in each of the case shall thereafter fix an early date for hearing of the petitioner. So, Mullah, this is a now, Mullah, my learned friends, Mullah, show cause notice is on 16th April 2024.
Correct.
Mullah, we filed the writ petition. Mullah, we also gave a letter because in other matters also, Mullah, the show cause notice itself has been challenged. We filed, Mullah, the writ petition, Mullah, on 3rd.
Other cases when the show cause notice was issued.
Sorry, Mullah.
In the other cases when the show cause notice is issued.
Mullah, there are various dates. I can, Mullah, give those dates, Mullah, immediately.
Okay, I will come on that.
Yes.
So here his contention was the 16th April, the first show cause notice was issued.
Then, Mullah,
Then you filed the writ petition on 3rd of May.
On 3rd May and 7th May, Mullah, I have given a letter which is, Mullah, at page 40 of the supplementary affidavit. Mullah, kindly have a look at that. Because, Mullah, my learned friends seem to, Mullah, turning, Mullah, the timeline on me and saying that you have not responded. I do not know, Mullah, what they were doing for 1 year.
Correct.
If, Mullah, they thought, Mullah, that, Mullah, page 40, Mullah, will find. At page 42, so we have also mentioned the suit. That is, Mullah, the suit is, Mullah, the substance of, Mullah, all writ petitions, because the suit is pending, Mullah, so far as these reports are concerned. Because the report was also prepared, Mullah, without any notice to us. That's, Mullah, our case. And, Mullah, they have disclaimers in the report itself, Mullah. I've appeared in that matter, so, Mullah, I'm aware of it. That is pending. Then, so far as answered, then, Mullah, sees last paragraph on the evening of 19, my client's been received the caption show cause notice. Issuance of the show cause notice has been challenged by my client's writ petition, which grounds from where such writ numbered as such and shall appear in the cause list of the honorable assets and such.
So you informed with regard to the writ petition.
Yes. So, Mullah, after that, no steps taken by them for more than a year. If my learned friend,
when that writ petition was disposed of.
This is the writ petition.
So this is
the writ petition. So after, Mullah, April 2024, when we, Mullah, filed the writ petition on 3rd May, after that, no steps. We told them this is the writ petition, this is, Mullah, what we, and in the writ petition, we have also made a paragraph saying that we have a schedule of documents which we want. So after that, no steps taken by them.
So, 16th July, 16th April, na show cause notice, you have filed the writ petition. After filing a writ petition, you have
challenging the show cause notice. We have informed them.
Informed the authorities, the bank. So thereafter, what has happened?
Nothing. First time, Mullah, notice came is, Mullah, on May 2025. 13 May 2025.
So, that's why supplement.
Yes.
Good.
So my learned friend, I don't know how, Mullah, he turns, Mullah, the timeline on me and say, no, you have not responded.
So your case is the pending writ petition, they have issued.
Correct. Because we challenge the show cause notice. Like, Mullah, in all other writ petition, Mullah, and I'll show, Mullah, in fact.
But the question which Mr. Diwan has raised, the document.
Mullah, I will answer that as well. I will answer that as well. Because it merits, because in all these matters, Mullah, what has happened? Money, Mullah, advanced, Mullah, by Punjab National Bank. They now turn around and rely on, Mullah, this KPNG and Saxena to say you have committed fraud. Now, what documents have I asked for? I'll show those documents. To say, Mullah, what has happened? Has the money come back? My learned friend says it's irrelevant. If the money has come back, he took, Mullah, one example. He says, how is it relevant whether the money has come back or not? I'm surprised because, Mullah, if the money has come back, where is the question of siphoning off? Where is the question of round tripping? That's, Mullah, his allegations, Mullah, in the report. Now, Mullah, kindly look at, I'll just come to that, Mullah. So, Mullah, the timeline is there for, Mullah, just to finish the timeline. I'm sorry, Mullah. So, 16th April, writ petition, Mullah, in May 2024. 7 when, Mullah, we informed them. Then, Mullah, the first time, Mullah, something comes is, Mullah, on 13th May 2025. That's the next, Mullah, step, Mullah, taken by them.
Correct.
13 May, Mullah, and 22nd May, Mullah, is when our reply.
22nd May, the personal hearing note.
Yes. Our, Mullah, reply, Mullah, asking, Mullah, for all these documents. Now, my lord sees in reply in again October, they say, oh, we have given you the audit report. In May, then my lord, next timeline is October.
Correct.
13 May, then October, they say we are giving you the report. That's 22nd May. And no dealing, and very important, my lord, not dealing with at all. What, my lord, my learned friend has argued now, my lord, I do not find, my lord, any evidence of, my lord, the bank coming is irrelevant.
So with regard to the 22nd SOCA notice, have you given any reply to that? 22nd October SOCA, second SOCA notice?
Yes, my lord, that's the one, my lord, which
That's we've given reply on 10 November.
There's a 53.
Yes. My lord, 10th November, my lord, page 49. Sorry, what? You must have a physical copy also, you know. My lord, kindly look at, my lord, page 149.
10th November. 10th November.
10th November. And where is this argument, my lord, which is now being made? Where is this, my lord, in writing? The bank saying that these documents which have asked for are wholly irrelevant. And my lord, the bank is aware, because my lord, the bank is part of, my lord, the resolution applicant, my lord, which has taken over, my lord, the company. All those documents, my lord, they are part of it. They know, my lord, we are out of it. We don't have the documents.
You stated that in
You can't, my lord, tie someone's hand, my lord, behind his back and then say you have a fight.
Yes.
Well, there is no response to that, saying that these are all irrelevant. Well, now I find, well, from the bar arguments are being made. No, these are all irrelevant. Because what have we asked for? We have said, because your appraisal is also there.
Yes.
You are accusing me. And Mulad, in all these replies, I'm sorry, Mulad, I'll just give one example. Mulad, he compared, because Mulad, he compared, Mulad, from page 66. Kindly look at, Mulad, page 360. First 362, Mulad, he pointed out. I'll just give one example, Mulad, like he gave Mulad 362 of Mulad, the volume 1, of the writ petition volume 2, and Mulad, the supplementary affidavit at page 66. But kindly, Mulad, take, Mulad, from page 62.
Yes.
Mulad, 42 onwards, Mulad, we explain.
Yes.
Mulad, 62, Mulad, will find the post disbursement audit.
Yes.
Internal audit team, paragraph 42, carries out sunset post to ensure proper risk management, compliance with the borrower, review plan commit the following: compliance of accounts, post disbursement condition, facility fees, drawdown condition, implementation sunset. And Mulad, we explain all that. Then Mulad, paragraph.
No, you come to paragraph 60, page 66.
Page 66, yes, Mulad.
Paragraph 61. Kindly,
Yes.
A, names and details of the officers of your bank, whether it is necessary.
Because Mulad, they are part of it, part of the disbursement.
Maybe, but
Mulad, let us assume, Mulad, that is not necessary. Let us assume, Mulad, I have asked for more details. You all also have to come back to say, no, Mulad, kindly look at, Mulad, GHI.
Copies of the appraisal report. Credit dimension.
Appraisal report, credit assessment member, prepared relation manager, regional heads. Then Mulad, H.
Yes.
Copies of the minutes of the meeting of the credit committee dealing with the approval, modification, appraisal loans which were disbursed and detailed in paragraph 1 of the SCN and in section 6 and 7 of the KPMG forensic.
Okay.
Then Mulad, K. Information of security. Because of the very high security for a loan, where's the question of Mulad taking it away?
Yes.
Then, my lord, I details of all the alleged connected entities, related parties, alleged potential, then copies of legal opinion and all that.
They've said the entities are connected, but
How the
Because, my lord, they say,
how the legal opinion, all the things be a necessary document?
my lord, because they say they're connected entities.
Connected in.
They're all related parties. Because, my lord, how do they come to this? You're telling me a whole set of, my lord, allegations against me. Because, my lord, kindly, my lord, also, my lord, appreciate the fact of the matter is, my lord, the KPMG and, my lord, the other report, my lord, is under challenge. Their, my lord, order has been preserved. My lord, if you had an order, that would have been end of the matter. But you are relying on those reports.
In that I passed the order. Single bench, in the suit I passed an order, I think, interim.
Correct. Malos, in that Saxena suit, there is interim relief declined. In the KPMG suit on the forensic audit report, the order is reserved.
Initially, my lord, there were orders. Then, my lord, it came up, my lord, and on the question of jurisdiction, it came back, my lord, to the High Court. So, my lord, I'm on the question, my lord. That's why, my lord, I'm saying now you're relying on that. Let us understand it is there, but you have to come to an independent your report as well. So, but I do not find, my lord, reply to this where they say that is irrelevant. Why are you asking for this? They do not, my lord, adhere to this at all.
Okay.
Now, my lord, in the judgment, my lord, which is already, my lord, there, because the same reports, my lord, have been relied on, my lord, in all matters. My lord, kindly look at, my lord, that bunch, my lord, which we gave also, my lord, or yes.
it is for the person who is defending the show.
Because, my lord, I have to, my lord, defend myself. Because, my lord, I am saying that these are the documents which are required. You have to respond to it. My lord, kindly look at, my lord, 9th August 2024, which, my lord, will find it is also annexed. I'm sorry, my lord, I can show it, my lord, from 294 of the sub. I'm sorry, I'll just show it from there because that will, my lord, in my lord's records then. 294. My lord, this is also a challenge, my lord.
Yes.
Similarly, based on, my lord, the at page paragraph 7 at page, sorry, kindly look at paragraph after, my lord, they serve the copy of the report, paragraph 5. So it's not a question of, my lord, only serving a copy of the report. Page paragraph 10 of this, my lord, will find
Director of fraud declare according to
Yes, along with all reports, along with all documents.
and, my lord, yes, and these are, my lord, all.
So this is an order on concept.
Outstanding, correct. Then, my lord, kindly come to, my lord, the next order, 23rd September 2024, which is, my lord, at page 300.
Yes.
There was still the direction.
Now, my lord, this is again, my lord, Indian Bank. The question involved in this writ petition is whether the petitioner is the promoter and director of the company, which is now before the successful resolution applicant, can be declared as fraud without any proceeding being initiated against the loan account of the petitioner without supplying the documents mentioned in the forensic audit report. Show cause notice issued by the bank is under challenge. During the pendency of writ petition, declaration of fraud was made. Very similar. The point raised is the bank did not supply the document forensic audit on the basis of which an opinion was formed. Petitioner company should be declared as fraud. The other point that is urged is that petitioner's company were taken over by National Asset Reconstruction, whose shareholders are the lending bank, including the responding bank, and they are in possession of the relevant documents. Yes. My lord, a finding. Although the learned advocate for the bank submits that the forensic audit report was supplied to the petitioner, the petitioner submit documents which formed a part of the forensic audit report and which were relied upon had not been supplied. As a result, but petitioner was not in a position to reply to show cause notice. Appears that the petitioner has not yet approached the bank, and kindly similar here. It appears that the petitioner has not yet approached the bank with a list of documents which he requires. Petitioner may apply. Here, my lord, we have already approached the bank. And there's no response to that.
Yes.
Petitioner may apply to the bank for a supply of such documents, and the bank may take steps accordingly. Inspection of all voluminous documents must be permitted. In the meantime, declaration of fraud dated May 20, 2024 shall remain state as this court is of the prima facie view that without furnishing the relevant documents which are mentioned in the forensic audit report, declaration could not be made. Let the affidavit stand such. Then, my lord, again, my lord, another order. This is, my lord, 19 March. This is there. This is there in the batch, not in the. Oh, it's not there in the.
No, but we'll give it.
My lord, that is there in the compilation. Again, my lord. Again, my lord.
No, 300.
300, my lord, is one.
303. 303.
303 is my lord's order.
1512. No, 1512 order the same.
Yes, that's my lord's order. My lord. There was another order, my lord, which was.
No, not my order. 303 is the order of the justice.
Oh, yes, 303.
No, my order.
303 is my lord.
My order.
303, my lord, there is, my lord, another, my lord, coordinate bench, my lord, which passed the order, which my lord has actually. In that bunch, my lord, is there.
Yes.
Similar, my lord, situation where also.
Proposed, then read, and then brought in.
My lord, on the question of, my lord, all documents, and in my lord's order also, my lord, said, it's not that, my lord, it's only transaction audit report.
All other documents.
Yes. Paragraph 7, my lord, is very clear. If the petitioner finds that any further document necessary for giving reply, paragraph 7.
Correct.
So I have asked for these because kindly look at my situation. I'm in an absolutely, my lord, helpless situation. I'm not in management thrown out, my lord, with my lord, my submission would have been different, but my lord, with my lord, RBI, my lord, interaction. Then, my lord, I don't have the documents. They are, my lord, part of, my lord, the forum, my lord, which controls it.
Okay.
And then, my lord, I'm not given these documents. My lord, I submit, my lord, this should be, my lord, set aside, my lord, or stayed, my lord, so far as 19 is concerned, my lord.
Mr. Diwan, only one question.
Yes, my lord.
Kindly come to the 215, which is the impugn. 215, that's the impugn order.
Yes, my lords.
Correct. Okay. I appreciate your submission, but the impugn order wherein you have declared the fraud after taking into consideration of the second so-called reply, but
Yes.
you have not mentioned yes what the document they have applied for that is not relevant. That's why you have not taken into consideration of the document and you have passed the order for declaring the bank as fraud.
My lords, kindly come to 292. There is a finding by the bank. So my learned senior was saying that we have not dealt with the issue of documents. That's inaccurate. It's dealt. Please look at 292. In fact, before 292, I'm sorry, your lordship will first look at 288. I'm so sorry, my lords. 288 first.
Yes.
288 is we reproduce the submissions made by the borrowers or rather the petitioners on 10th of November. Identical submissions. At 288, the entire thing is extracted. Now, in light of this, please look at the committee's view at page 292.
288, which paragraph you are relying upon?
Well, it's 288, I was only pointing
that
out.
is okay.
That is what they have said. That is what they have said.
Okay.
Please look at 292, committee's view on response. Now, it's not that the committee has not applied its mind.
Yes.
Just look at the bottom. 292. Yes, 292, bottom of the page, your lordship will find a heading called Committee's View on Response.
Kindly look at.
Yes.
In response to the opportunity for a personal hearing, borrower has submitted a written representation emphasizing the need for access to additional documents and immediate disclosure of relevant records beyond the forensic audit report. Please mark those words.
Correct.
That has already been shared. Borrower has asserted that in the absence of these documents, any hearing would be a mere empty formality, could not be perceived as prejudged. Borrower has requested the hearing be deferred until requested documents are made available. However, it is important to highlight that all documents relied upon, including the forensic audit report and its annexures, have already been provided to the concerned parties. Moreover, the factors underlying the allegations of fraud, as detailed in the show cause notice, are based on the transactions between SRE entities and their customers. These records are already within the possession of the borrower. Therefore, repeated requests for additional documents appear to be an attempt to delay or disrupt the fraud declaration process. So the point that we are trying to make is only this. You have the forensic audit report, you have the annexures. Now, what you are asking for beyond this, I can understand if you establish the relevancy of that. The allegation is you have siphoned away money, not that the bank has siphoned away money. But what they're asking for is give me bank's details, give me bank's reports, give me bank's appraisal documents. All of that is completely irrelevant. And Mullahs, as I said, there's one other small point I want to make. Again, Mullahs, I'm re-emphasizing the point. Someone can point out that in the absence of a particular document, I'm incapacitated. But that has to be shown as a matter of fact. It can't be a general sweeping allegation. Unfortunately, Mullahs, the petitioners have made this matter as is a matter between them and the banks. No, the banks are not getting any money out of fraud declaration. So our attempt is to only comply with the RBI master circular. We are complying with a statutory obligation. That's all that we are supposed to do. And one, sorry, I'm repeating one point. My friend says that as if the filing of the writ petition on 3rd of May 2024 amounts to like a de facto stay. How can that be? If a show cause is issued, he's supposed to give a response. Filing of a writ petition doesn't mean that he's not supposed to give a response to show cause. That's the argument that I wanted to make when I was arguing the matter. That's all. Now, the other matters. Other matters. So in this matter, there is an order of fraud. Insofar as Karnataka Bank and DBS are concerned, there are three other matters. So Karnataka Bank is item 20 and DBS is item number 22. Here, my submissions are very short in both these item numbers 20 and 22. There is no fraud declaration order. Point number one.
Correct.
Point number two, please make a note in Karnataka Bank, the date of the SCN is 19th of March 2024.
Just a minute.
Yes, I'm sorry, Mullahs.
Item number 20, what is the contention?
Yes, item number 20, the SCN is 19th of March 2024.
Date.
And in item so Mullahs here,
item number 20, what is the
March,
date?
19th March.
19th March.
There is no fraud declaration. 24.
24. Yes.
Mullahs, now, despite the show cause being of 19th March 24, no response to the show cause.
Whether your forensic report has been served upon the party?
Yes, admittedly. In item 20, forensic audit report served with annexures. Show cause is 19th March 24.
Correct.
We are today in January 26. No response to the show cause, no request for documents.
Okay.
So according to me, this writ petition should be dismissed.
Yes.
Because the previous order of 2nd of February 2024 asked them to give a response.
Correct.
You cannot only file a writ petition and not give a response.
Correct.
Likewise, now let's say in item number 22, which is DBS.
Yes.
Show cause is 24th of July 2025.
20 July.
24th July 2025.
Yes.
Only writ petition challenging show cause filed, no response to SCN, no request for documents. So according to me, the writ petition is premature, should be dismissed.
Yes.
Because only filing a writ petition does not mean that there is a de facto stay on the process. Now, that now leaves me with item number 21, which is Indian Overseas Bank. Now, in this case, I want to be absolutely candid and frank to your lordships. Please don't record my statement. I'm not making concession. But in Indian Overseas Banks, there seems to be a problem against me. So I must candidly say, in this case, it appears that fraud declaration happened without giving them the SCN. So your lordship may not kindly note that I have conceded anything, but I am being very, very fair to the court. In this case, there is a fraud declaration which appears to be without SCN. Therefore, my lords, that of course is not in consonance with law. And your lordship, my lords, will pass necessary orders insofar as IOB is concerned. But in this matter, my lords, only one point I want to tell you. There are judgments of Supreme Court which say that even if the fraud declaration order is set aside, then the bank is at liberty to restart the process.
Correct. That always.
Correct. Absolutely. So if your lordships only in item number 2021, no other case, if your lordships are persuaded to set aside the fraud declaration order, kindly give the bank the liberty to restart the process in accordance with law.
Okay.
But in other matters, I am requesting for dismissal. And in item number 19, I am saying I will file my reply to the writ petition. But no interim order.
I will dispose of all the matter. I will let me see. I will
Okay,
dispose
very
of
well.
all the matter, keeping pending all the nothing will happen, either this way or that way. Then
Very well, Manoj. Well, I'm so deeply obliged, and I must apologize again for my network connection today. I'm sorry.
Which one? Yeah, that's that I have gone through. And with regard to the item number 20, 20 and 22, the same. No, so cause notice is challenge, you not file the reply, you record the document. That's all. That's all. Thank you. Thank you.
Thank you, Manoj. I'm grateful.
Item number 19 to 22. Hearing concluded. CAV. All the Sara files. Page there. CAV, yeah. Take it. Yes, next. 12 p.m. 12 noon, man. Order. दो फाइल अच्छे
This is not the others which are fixed by your hospital. Right from the MSc order. That is and from the next negative. Clause. And look at them that they have not contract reserves. How it is written as something division that the government is taking cost of same and contribute under the jurisdiction of Durga Education. Upon a result of the order cited in the report by the state evident that even on that date, however, an aboriginal assures that he will take so that the prisoners are placed in some other state outside. Good question. Obligation of the state to bring them back.
completion of
And they are to provide this. It is not that the petitioner has their wisdom and bravery and desire to find out a particular government which they are very objective from day one. They want to hear every chance or obstacle. Now that is one part. Second part, as if you kindly allow me to take one.
which one? Yes.
This is not particularly, there are so many matters pending. This is an interim. So what is the interim method? Then come. Show me stage. Then come to last portion. I cannot hear honors. Supreme Court.
Yes, I am.
Undoubtedly, if any person is put to trial for a particular offence, be it a citizen of this country or he may be an illegal, once he's tried, sentenced, and has undergone the sentence, he cannot be kept in prison. But at the same time, he being an illegal migrant has to be kept in correctional home, detention center, due sense. Therefore, he has to be, Supreme Court's observation was, he has to be after release to be placed in a correctional or detention. Unfortunately, the state of West Bengal does not have a correctional home, and therefore the apostate is a little delicate issue and should be looked into by the state of West Bengal at the earliest. Everything is a direction, observation, obligation of the state. Now then, 15. We are informed by the Landed Council for the state of West Bengal that state government is coming up with a separate correctional home detention center, and the construction is likely to be completed. 16. We do not know when the construction will be completed. We are of the view that if there is any legal within the state of West Bengal who has undergone the international confined, any of the presidents past year from date of completion of his original sentence, he is released on bail subject to the following conditions. Therefore, the conditions imposed by the state of West Bengal here is to be read along with the order passed by the Supreme Court directing the state to construct this correctional home. This is not an independent finding by the Supreme Court. That even if state merely will be given, will be scot-free, they will not construct it, and they shall be placed before a place at the convenience and desire of the petitioner. Then paragraph 22. It is needless to clarify that no sooner the construction of correctional home detention center is completed, then immediately thereafter, all such illegal immigrants are shifted to such correctional home detention center. So what is the conclusion? It has to be read as a whole. The order has to be read as a whole.
Correct.
There was this order undertaking that they are constructed within 6 months has not been extended.
Yes.
And my lord, your lordship is aware, under the new law for Immigration and Foreigners Act, what is the obligation of us? We have, pursuant to your lordship desire, the FRRO has sought this specific instruction from the Home Ministry, and they have now come up with an affidavit. The lordship will kindly allow us, at least in this time, to file the affidavit disclosing what is the obligation of the state and what is the obligation of the state and government of India. That apart, this order of the Supreme Court was passed in May 16 May 2025. Thereafter, the new act in September 2025 has come into operation.
Last order.
There was simplicity by giving an address, we are very well objecting the border area that your lordship cannot have.
Okay.
And this is the affidavit. This is the affidavit, my lord, we are seeking. Kindly give some this so that we have filed legal affidavit disclosing all the question of law and other files and the other matters which are pending. All these matters have to be heard by your lordship. This is a larger implication, not only in this case, but
My lord, a copy of the affidavit may be served upon us, my lord, because we have not been handed over any copy. Sir, actor hai, Arik Prakar.
that matter I have handed over. That is still pending. That all these matters can be done. Fix the date. We shall file within 10 days an affidavit disclosing the stand of the Home Ministry and the FRRO. Because your lordship has included the External Affairs Ministry and the FRRO. But that about immigration, your lordship is awarded in the jurisdiction of the Home Ministry. And the FRRO is under the jurisdiction of the Home Ministry. This is a national issue, act of sovereignty.
Okay.
And cooperation is required in this matter to set up a because this board also had an obligation.
He's on his legs in court 5. I think when he's going on.
Okay. Okay. Yes. Let me hear.
My lord, if I may, my lord.
No, what the state?
Well, I'm led by learned advocate Jeremy. He's on his legs in court 5, my lord. Kindly, my lord, short form.
How it can be? What is the whether you have identified the
On the last occasion, lordship direction was that you are to hold an inquiry with regard to the persons
correct
where this petition is willing to rehabilitate himself. We have already inquired into the issue. And it is found that yes, no, the places where they are willing to go, my lord, those two places, the very persons, they say, no, we don't want to accept them. Both.
But the first
No, so far as Faridul Islam matter is concerned, it is item 15. Ek minute. Amar SMG ta Lordship may kindly, my lord, on the last occasion, the first name given, verification report placed before your lordship. Now with regard to the second person.
This is with regard to the which writ petition?
Item 15.
15. Item number
Faridul Islam,
Faridul Islam.
lordship.
Yes.
On the last occasion, my lord, Faridul had given the name of one person where he wants to rehabilitate himself. So we already filed one report, my lord, on record, that where he wanted to go, that person said, no, then that person that person has criminal antecedent. Now thereafter, Faridul has given the name of second person. Now, so far as the second person's inquiry report is, let us say, excited. My lord, this report just now I handed over, my lord.
Injamamul Haq with regard to the which petitioner? Second petitioner.
Yes,
Taslima and another. And with regard to the other, Rintu Mandal. Miss Mingle with the
already submitted report that there was one.
My lord, I am on Faridul Islam matter, my lord. Faridul Islam in Faridul Alam. Initially, he wanted to go to the residence of a man whose name was Rintu Mondal.
Correct.
So that report is adverse.
Correct.
Because Rintu Mondal has criminal antecedent. Now the second issue, Faridul Alam gives a second name. His name is Riyab Ali Mullah. So now, just now, my lord, I have respectfully handed over a bunch of documents.
Correct.
May I respectfully invite your lordship to page 3 of the document.
Yes.
So Riyab Ali Mullah was the name given. We inquired into the issue. Kindly seize, my lord. The report is at page, my lord, 4, my lord.
My lord, if I may, my lord.
Yes, it. At page 4, my lord, last 4 lines. I get a copy. Last 4 lines, it was with due respect and humble submission, lordship got the report. I beg to report a message copy of receipt from Damdam Correctional regarding Riyab Ali Mullah, resident of Nautala, landmark near so and so. It was verified. It was found that the said address falls within jurisdiction of Joynagar police station. Further verification revealed that Riyab Ali Mullah, son of so and so, is a resident of village so and so, being so and so. He was arrested in connection with Techno City Police Station PSS number so and so under section so and so NDPS Act, and was subsequently released from Damdam Correctional Home on 17 June 2025. It was also learned during inquiry that while lodged at Damdam Central Correctional Home, Riyab Ali Mullah became acquainted with Faridul Alam. The said Riyab Ali Mullah has clearly stated that he is not willing to keep or accommodate Faridul Alam at his residence. So this is with regard to inquiry of the second person, Riyab Ali Mullah. Now again thereafter,
another person.
He gives the name of one lady that is at page 5 of the bunch of document, Masura Khatun.
Correct.
So we held an inquiry. What does this lady say, my lord? Kindly see, my lord. Kindly seize, my lord, at page 7, the last page of the bunch of document I have respectfully handed over to your lordship. At page 7, lordship. In connection with so and so, after endorsement Matia police station, I inquired into the content of your message. During inquiry, I had been to the village to verify the address of so and so lady, and it could be learned that said Masura Khatun resides at so and so. Asking, she stated that she does not know any person in the name of Faridul Alam and could not recognize him. So this is, my lord, in compliance with your lordship's direction on the last occasion. This is the compliance, my lord. We are, my lord, filing, my lord, today. And regarding rest of the argument, my lord, let the, my lord, learned advocate general comes and he will address your lordship.
I am submitting the person to the argument.
And there was, sir, there was a direction upon the FRR also, my lord, to submit a simultaneous inquiry report.
Lordship will kindly consider on the basis of the name disclosed, if that be the state of the affairs of the report of the state of West Bengal, whether this petitioner can be at all entrusted
such a grave matter.
Copy
To disclose such names,
copy দিয়েছে
and they are knowing the,
State of the
how do
state
they
of-
know the name of these people? And
Yes.
in spite of this, no question of not giving them any leverage. This is national issue and sovereign issue.
Okay. And what about the second petitioner? This Taslima and Ada?
Oh, that matter is represented by Mr. Amol Sen, the learned additional advocate general, my lord.
That report is already
That you have
Placed it.
submitted the last
Oh,
report.
on the last occasion, was it placed, my lord?
Yes.
I think there is no advance report so
Correct.
far as that matter is concerned. You place it? Shall I, my lord, may I place, my lord? Sir, the petitioner, the copy.
Give the report.
My lord, this is, my lord, with regard to that matter. May I respectfully hand over, lordship. 2nd January, my lord, 2026. তাহলে এই ফাতিমা মারতে হবে। এটা তো আমার এটা তোমার ডিউটি অমলদা এখানে ডিসক্লোজ করছি তো আবার রিপোর্টটা দিয়ে ম্যাটারটা দিয়েছি এটা হলো
আমাদের
Already
কাজ কিছু করার
No. With regard to this, Taslima, who will be the surety? Taslima, where is that?
Well, that will be, well, I've already submitted on the last location.
That is the problem.
That report is
That time, sir.
but there is no adverse report
এইটাতে
yet.
কি হলো এই যে দুজন আছে হাজব্যান্ড ওয়াইফ এনারা আজকে বলছে যে ওই অ্যাড্রেসটা সেটার ক্ষেত্রে আমাদের পুলিশ রিপোর্ট হচ্ছে ঠিক আছে ওকে অসুবিধা কিন্তু সেকেন্ড
Where you are keeping all the documents? Last document they have submitted the report. Where are the reports?
বলছে
Very difficult to deal with that.
কি হলো এটা just now we have handed over the report as well as this report also
না না এটা
these two reports
মানে একই ব্যাপার হচ্ছে
বাকি ওরা কি সাবমিশন করছে স্যার আমি exit code file
You submit, where is that? You have a copy?
কোনটা কোনটা কোনটা
জমা দিয়েছিলাম স্যার
কি জমা দিয়েছিলেন বুঝতে পারছি না
petition on the basis of the
মানে
Oh,
তাসলিমা
prisoners petition, my lord, I think, my lord, it has been
Part of the
annexed to part of the, my lord, the report. No,
Which report? That's why that is not there.
no, 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 no. আমার ব্রিফটা কোথায়? ব্রিফ টিপ না দিলে আপনার কি করবো?
You're not having the copy? Because आप लोग सब पिछले बार का सारा रिपोर्ट से हम लोग कौन सा फाइल में डाल के गए हैं? सारा फाइल का तो बराबर करके क्यों
Because you know what was this report already handed over. Okay, Taslima will have the problem.
So Injimamul Haq is with regard to Taslima.
Yes.
No, Tasliqul Islam have given the name of Acha. Yes. He is the trustee person. And with regard to the other, they are not the trustee person.
With regard to other, my lord, the initial report that is, my lord, that he wanted to be in his custody, my lord, there it appears from the earlier report that not less than 6 police cases are pending, so we refused. Then, my lord, substitute, my lord, the names, my lord, the place. Now, my lord, out of those 2 substitute names, my lord, one, my lord, both, my lord, refused to accept her.
Okay.
And that is, my lord, reflected
what
in
about
today's report.
So what is your status with regard to the correctional home and detention home?
Now, my lord,
what is the status?
Now, my lord, so far, my lord, the present writ petition is concerned. My lord, first of all, my lord, the learned advocate general was addressing your lordship. Today, he is engaged in other court.
You are competent. No, there is no.
I am not on that. I am not.
Why?
But the thing is this, that my lord, so far, my lord, we thought for, or we realized, it was our, my lord, the assumption is that my lord, that in these 2 writ petitions, my lord, 3 came up. In one writ petitions 2 and other writ petitions 1 came up.
Correct.
Now, my lord, on the basis of the, my lord, the Supreme Court's order, my lord was kind enough to, my lord, grant them, my lord, liberty to place the name so that in whose custody they will be, my lord, they are justice itself. And my lord, time to time they will, my lord, report it to the police station. Now, my lord, so far that, my lord, the 2 persons are concerned in one writ petition, husband and wife. In their case, my lord, there is no problem so far, my lord, the state is concerned, my lord, the police report says. My lord, the other is that we are not satisfied. One, and see the replaced names, they refuse to accept. So it is his problem right now. So, my lord, let that first writ petition be disposed of on that basis of the Supreme Court. No, they may have objection. I am not on that. I am not.
No,
on
that is correct. That the court will decide. I heard the matter.
Yes.
What
Now,
about
my lord, on the last occasion, my lord, the learned advocate general, my lord, made his submission before your lordship is that the matter is still pending before the Honorable Supreme Court. And my lord also gone through the judgment, and it appears that the Supreme Court is monitoring the matter, everything. Now, my lord, it was his submission of the advocate general, and it is my submission also before your lordship, is that the scope of the writ petition is, my lord, restricted to this. Lordship, kindly consider, scope of the writ petition is restricted to this, my lord, the individual 3 persons. Now, so far 2 persons are concerned, husband and wife in one writ petition, their problem can be solved in terms of the Supreme Court order. Because Supreme Court said that in this way, they can be released for the time being. And so far the 3rd person is concerned, my lord, the problem is that they themselves is created because of the fact they are unable to place a trusted person. Either trust, my lord, we can, my lord, repose, or the person concerned in whose name favor, he is not willing. So let another chance be given to them. So
no, that's what chance is given.
Now, my lord,
But the state is also having some burden.
Now, my lord, today, may I tell you, today, my lord, because of the fact, my lord, that the matter is still pending before the Supreme Court and all the issues are pending, including all, my lord, he may say, no, my lord, I am not on that. But I am not so learned man to read. So now, my lord, lordship, kindly consider one thing, that in these circumstances, whether, my lord, the scope of the writ petition can be extended in that way or not, my lord, I would beseech your lordship.
Okay.
But lordship, kindly, my lord, then, my lord, keep it on any other day.
No,
my lord.
I have only one submission. Kindly come to the Supreme Court order page 16. I have already submitted the entire order to be read as a whole.
Correct.
No question for isolation. Even if it is isolated. Page 16.
My learned friend is, my lord, harping on a particular paragraph. We are on the entire Supreme Court judgment.
See, every advocates, every party is entitled to what they are relied upon. No, leave upon this court what the court will bring.
Yes, that is true.
Yes.
That is true.
Kindly come to page 16 of the Supreme Court order. Even
Yes.
if it is taken as an isolation.
Correct.
Clause B.
Yes. He or she specify the verify address stay after release.
Verifiable address.
Correct.
Is it by the state government? Under
No,
the new act of, earlier act.
No,
we have obligation.
let them verify. We are not on that.
We are
Yes.
objecting for the day one is the border area, there is every chance of committing crime and absconding.
Has the
Okay.
name been given to us?
That's all.
We have given, we have
Affidavit is
we're giving advance report.
That's all.
Yes.
My lord, with respect to the first order that was submitted, my lord, I would like to point out that I had only relied on that order, my lord. I had appeared in that matter as well, my lord. And
Which matter?
my lord, the Begum that was handed over to your lordship, 28th
Correct.
July, June 2023 order. My lord will see, I was one of the petitioners in that matter. My lord, in that, a coordinate bench of this High Court reiterated that they cannot be kept in jail forever. And since they were women, they were sent to women home. And after that, they have been released and handed over to their husbands and relatives. My lord. That is the position. So, my lord,
Yes.
I will just pray, my lord, since Faridul Alam is concerned, my lord, that week, my lord, we'll come back with instruction, but with regard to the other.
Item number 15 order karo. WPA 2878472 of 2024. The petitioner has filed the present writ application praying for a direction upon the respondents to release the petitioner who is at present lodged at Aura District Correctional Home on disclosing his destination for residence and on undertaking to report the local police station. Local police station. The petitioner was charged with the offence under section 14 Foreigners Act and
Mention Rachi copy to. We copied on any.
in completion of the investigation, the police has submitted charge sheet. On the date of recording, on the date of framing of charge against the petitioner has pleaded guilty for the offence under section 14 of the Foreigners Act. Accordingly, the London Judicial Magistrate First Class 7th Court Aura has sentenced the petitioner to suffer simple imprisonment for 1 year and 3 months, that is 445 days. It is further ordered that the period of detention, if any, undergone by the petitioner for a period of 1 year and 3 months, that is 445 days, be set off against the sentence passed under section 428 of the CRPC. It is further ordered that all the petitioners being all the accused persons being the Myanmari nationals be repatriated to their native country at once upon expiry of the sentence imposed. The London magistrate has passed the order of sentence by an order dated 3rd May 2017. Counsel for the petitioner submit that when he was originally arrested,
2016.
and since then he is on custody, counsel for the petitioner submit that initially the petitioner was arrested on 29th of February 2016, and since then the petitioner is in correctional home. Though the London magistrate has passed an order of conviction sentencing the petitioner for 1 year and 3 months, but the petitioner is in correctional home for the last 9 years.
Almost 9.
For the last about 9 years.
Because the sentencing got completed on
9 years, police.
2017. Sentencing completed on 8 April
And at counsel for the petitioner submit that the sentence imposed upon the petitioner has been completed on
17.
when?
8th April
8th April 2017. Full stop. On completion of the sentence, the petitioner has made an application before the London magistrate on 27th of June 2016 with the prayer for following the order dated 3rd May 2017, wherein the London magistrate has directed for repatriate the persons to their native country at once on expiry of the sentence. The London magistrate, by an order dated 27th of June 2016, has dismissed the application filed by the petitioner on the ground that the London magistrate has no jurisdiction to pass any further order once he has already disposed of the criminal case by imposing sentence upon the petitioner. Full stop. The petitioner has relied upon the judgment in the case of MS Maja, Daruwala and another versus State of West Bengal within bracket transfer case within bracket criminal number 1 of 2013 dated 16th May 2025, wherein the Honorable Supreme Court has passed an order holding that if there is any illegal migrant as on date in any of the prisons within the state of West Bengal, who has undergone the entire sentence and is still confined in any of the prison past 3 years for the date of completion of his or her original sentence, he shall be released on bail subject to following condition. This set out page 60. This to this, A B C D E, page 16 of the judgment. Counsel for the petition submit that the judgment passed by the Honorable Supreme Court equally applicable in the case of the petitioner, as the petitioner is languishing in the correctional home even after the completion of the sentence in the year 2017, but he has not been, neither he has been repatriated nor he has been released from the correctional home. The petitioner the superintendent of Damdam Central Correctional Home, by a letter dated 23rd December 2025, has informed the superintendent, the welfare officer Damdam Central Correctional Home has informed the superintendent Damdam Central Correctional Home, Kolkata, that the petitioner is ready to give surety for release on bail. The detail of the surety has been given as follows. Rintu Mandal, son of Abdul Aziz Mandal.
Rintu Mandal is Faridul Alam.
Faridul Alam, that's the item number. Abdul Aziz Mandal. Item number 1 is the Faridul, na? Yeah, Abdul Aziz Alam, village Khuri Gachi, landmark near Golpadra Angari school, dekh lena. This one. Okay. Police. On receipt of the petitioner has produced the said report before this court at the time of hearing. On receipt of the said report, this court directed the state as well as the FRRO to verify the address of the surety furnished by the petitioner through the welfare officer of the Damdam Central Correctional Home, whether he is a reliable person and the petitioner can be released on bail if the petitioner will reside in the address mentioned. Full stop. As per the direction passed by this court, the state has submitted the report stating that the Rintu Mandal is a habitual offender with at least 6 registered criminal case against his name, and accordingly the state has objected that the credence that the character that the Rintu Mandal is already involved in several criminal matters, and if the petitioner is allowed to reside with the said Rintu Mandal, there is every apprehension that the petitioner will again commit an offense with Mr. Rintu Mandal. Leonard DSGI has submitted that the Honorable Supreme Court in the order dated 16th May 2025 submitted that the condition for release of bail can, as indicated in the order passed by the Honorable Supreme Court, cannot be read in isolation. He submitted that the Honorable Supreme Court has passed several directions, imposed several responsibility of the state of West Bengal, but till date the state of West Bengal has not come forward with any report whether the state of West Bengal has made any arrangement for keeping the migrant in a correctional home or detention center.
In spite of there are
Full stop. He further submit that in the order of the Honorable Supreme Court, it is categorically mentioned that the state of West Bengal has made an statement before the Honorable Supreme Court that the separate correctional home / detention center is likely to be completed within a period of 6 months. He further submit that the petitioner is a Bangladeshi Rohingya. No, is a Rohingya. Is a Rohingya. Is a Myanmar. And if the petitioner is allowed to go on bail, there is every apprehension that he will commit a further offense and will disturb the peace of the West Bengal, state of West Bengal. Full stop.
Well, may I interrupt only?
I will record here. I will record.
No, I'm not on that. Well, as per instruction, my lord, it appears that it is instruction for officer in charge law cell, Directorate of Correctional Service. My lord, it appears that since completion of his sentence, he is housed at a temporary detention camp, which has been created inside the premises of Dum Central Correctional Home, Fire Department Correctional Administration. Now, my lord, I am Advocate General is here, Lord.
Give that report.
No, detention camp. Now,
give the report.
Detention camp. আসছি
Yes.
না এইটা ওদেরকে টেম্পোরারি ভাবে রাখা হয়েছে কারেকশনাল হোমে অ্যাজ এ ডিটেনশন ক্যাম্পের মতো পার্মানেন্ট কিছু করা হয় অর্ডারটা দিতে যাচ্ছেন সুপ্রিম কোর্ট ডিটেনশন ক্যাম্প করতে বলেছে আমরা এখনো করিনি সেইটা নিয়ে
But only one thing, Milord, but on the issue of detention camp, my understanding of the Supreme Court's order is that it is pending consideration before the Supreme Court. That is why the Supreme Court says that till such.
That's why I am not passing with regard to no. Only I am recording the submission. The DSGI, you have made a submission before the Supreme Court, but till today that there is no detention home or the correctional home or detention center has been constructed.
And therefore, the remedy has been provided by the Supreme Court itself,
So that
saying
is-
that if somebody has completed the period of conviction
That's
and
now what is the stage? You have made an undertaking before the Supreme Court. What is the stage of the construction?
But
Is there
Milord, please have a look to Milord the order once more, Milord. Milord, dear Lordship has gone through the order, Milord, I'm sure.
Can you see paragraph 15?
Yes.
State of West Bengal, that the state of West Bengal state government is coming up with a separate correctional home detention center, and the construction is likely to be completed within a period of 6 months.
Please see the next sentence.
Correct. We do not know
When the construction would be completed, we are of the view that if there is
that I have recorded.
yes, yes.
That I have
Yes.
recorded with regard
But
to.
I personally feel, because of this, subject to correction, that this issue of detention, setting up of detention centers is pending before the Supreme Court. That is why the Supreme Court says that at para 17, we are of the view that if there is any illegal.
No, that is correct. I am not only, I am asking whether any construction is going on, whether any land has been, place has been identified.
And please take me at para 21.
Yes, because if they've been released of your construction, then they have
to be removed, and in the meantime, yes.
That is correct. That is okay. The person who is able to give the address where he will reside.
Yes.
The person who is not able to give, having any place of residence, what would be the effect of?
A temporary detention camp has been created inside the Dom Central Correctional Home. We have issued a notification to that effect on 1st of March 2019.
2019.
2019.
So where is it? Is in that correctional home?
No. Detention center.
How it can be?
Milord, may I tell you, Lordship, Milord, in a correctional home, there can be prisoners. There can also be, Milord, persons, as we have tried to do.
But already completed their
place
sentences.
is set apart for these persons who cannot be treated as prisoners also.
Yes.
And those who cannot be let out in the society.
No, for that, if the Foreigners Act, where is the new act? Earlier Foreigners Act, now it has been.
Yes, now
if
it's
a
a new one.
person has been released or he completed his sentence, so he cannot be treated as a convicted. He has completed his sentence. Now he should be in the detention home and with the observation of the civil authority.
Yes.
And civil authority is to be appointed by the central government.
Yes.
Central government. If you are telling that another room has been prepared, that is not in consonance with the law. That is not in consonance with the law.
That is
so what is the difference? If he is not in this cage, he is in separate place. What is the? But it is the correctional home boundary only.
No. May I say this, Milord? In this room, your Lordship is on that side. I am on this.
Correct. That's why it's the same room. Room number 25 only.
So,
All this is for temporary.
In that case, may I take instruction on this 1st of March 2019 notification?
If this correctional home, you could have been taken some other outside of the correctional home, and you've been informed to the central government, and central government will appoint a civil authority, and civil authority will look into the what we said, the jurisdiction, and where they will pass appropriate order, with restriction order of their movement.
But what about para
But I'll sit with them and come back.
That is the only thing.
Please keep it on Monday.
What about para 17? সেখানে তো দুজনের বেলায় আমাদের কোনো অসুবিধা নেই, আমরা বলেছি সেটা তো রিটটা ডিসপোজ অফ করে দিতে পারে।
Immigrants and foreigners.
Correct.
সেকেন্ড পিটিশনে যে দুজন
Immigrants, yes, now it has been segregated.
নাম দিয়েছে, সেখানে আমাদের কোনো অসুবিধা নেই, সেও নিতে রাজি। তাহলে ওই রিটটা তো ডিসপোজ অফ হয়ে যেতে পারে, যেটা জজকে বলছি।
Correct. That's why the detention home is required. That's why the detention home is required. This movement is to be restricted. And who will restrict? Not the local police. Movement is to be restricted by the civil authority. So unless and until you will not identify the correctional home or detention place outside the correctional home, because the civil authority will not go to the correctional home.
এটা entirely paragraph 17 of the judgment.
Till it is
তো টাইম টু টাইম আসবে, রিপোর্ট দেবে, যেটা জজকে বলতে। এই রিটটা ফেলে রাখার কি আছে?
That this paragraph will apply. And even if it applies, it is verifiable by us.
Same submission was made by the state government in 23 matter that was placed.
Correct.
Over there, that the
Yeah, क्या बोला? Cannot be. Is Myanmari, not Myanmari. 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 Full stop. The full stop. Had the Leonard Council for full stop. The Leonard DSGI has filed a report praying for time to file a detailed affidavit within a period of 4 weeks from date. Full stop. Had the Leonard Council for the respective parties produced the materials on report. Admittedly, the petitioner is a Myanmari national and he was apprehended by the police and on inquiry it was and apprehended by the police for the offence under section 14 of the Foreigners Act. The petitioner has pleaded guilty before the Leonard trial court and he was sentenced to suffer simple imprisonment for 1 year and 3 months on 3rd of May 2017. The petitioner has completed his sentence in the year 2017 itself. But as there is no detention home or detention home or correctional home, there is no facilities of the detention home, the correctional home, and as such, the petitioner is detained in the correctional home itself. Now, the matter is pending before the Honorable Supreme Court with regard to the construction of the correctional home / detention center. The state government has to file the report before the Honorable Supreme Court with regard to the status of the construction of the correctional home / detention center. Now, before this court, the only grievance of the only consideration that whether the petitioner can be released in release on bond in terms of the order passed by the Honorable Supreme Court dated 13th of May 2025. Full stop. Considering the judgment passed by the Honorable Supreme Court, this court has the address furnished by the petitioner was sent to the state as well, was referred to the state as well as the FRRO for verification of the address. The state authority verified the address and found that the address, the name in whose care of the petitioner intend to reside is having several criminal antecedents. And as such, this court did not find that the said person can be, and the petitioner can be allowed to reside in the said house. The petitioner subsequently furnished other 2 addresses, namely, what are the 2 addresses? Where is that?
আমাদের রিপোর্টটা দিয়ে দাও না তাহলে
দেওয়া আছে
এটা না কালকে যেটা
এই যে এটাই তো
Rayab Ali Molla.
রায়েব আলী মোল্লা
Rayab REYAB. Rayab Ali Molla, son of Rahim Molla, village Nyotala, landmark hi kar dena.
একটাই তো নাম দিয়েছি
And another person, namely Masura Khatun, daughter of Dr. Dawood Mullah.
এখানে একখানা কাজের জিনিস
The state authorities also verified the said addresses of the said 2 persons. And on verification, and after verification, a report is submitted before this court, wherein it reveals that when Mr. Rayab Ali Mullah lodged at Damdam Central Correctional Home, he acquainted with the petitioner. The Rayab Ali Mullah has categorically stated before the authority at the time of inquiry that he is not willing to keep the petitioner at his residence. As regard the inquiry of Masura Khatun, it is found that she has categorically stated before the authority at the time of inquiry that she does not know any person in the name of Faridul Aslam, and she could not recognize him. Considering the report, this court find that the two persons' names which have been provided by the petitions are also not ready to allow the petitioner to reside in their house. Considering the above, this court find that, and this court has no other option but to reject the application. It is true that the petitioner has completed the sentence in the year 2017, but petitioner is a foreign national and he cannot be allowed to go freely as Indian citizen. And if he is allowed to go free, only furnishing a bond, there is every apprehension that either he will flee away from the island, India illegally, or he will further commit any offense in India. Police. It is further made clear that this rejection order will not prevent the petitioner to make further application if the petitioner will find any persons who is ready to keep the petitioner is resident in the state of West Bengal in future. That's why it got that's why I have given. It will not prevent you. As to somewhere, you will not, the court is here.
But this expedition is
All the thing cannot be in the apprehension. Why? Dismissed.
this is item 15.
Item 15. Item number 16. Item number 16 verify. The same order, no? Conviction order is the same. By the same order, they have been convicted. All the things is item number 16. But here, because the petitioner has submitted, and the no petitioner वो जगह एक जगह हम लोग बोला ना कि welfare officer has submitted, वहाँ से आएगा. The welfare officer submitted a letter to the superintendent, Damdam Central Correctional Home, on 23/12/2025, intimating that the petition, if the petition is released on bail, the petitioners will reside in the house of Injimamul Haq Tarafdar, son of Mustafa Tarafdar, village Kolsur, कर देना address. ठीक है? On receipt of the said detail of the person, Injimamul Haq Tarafdar, this court has requested the state as well as the FRRO to verify the address furnished by the petitioner if the petitioner is released on bail, whether it is if is released on bail, he can reside in the house of Injimamul Haq Tarafdar. The state has submitted the report informing that on inquiry it was found that Injimamul Haq Tarafdar is residing in the said address for a long and no discrepancies has been noted during the inquiry. The learned DSGI has raised objection and submit that though the state has filed the report that the petitioner can be reside in the house of the Injimamul Haq, but the state has not filed any report whether the petitioner can be flee away from India illegally or whether the petitioner will
This is also covered the border.
what?
Border.
Or whether the petitioner will commit any further offense while on bail. At the counsel for the respective, the DSJ have filed a report in the form of affidavit, praying for 4 weeks time to file detailed affidavit. Full stop. Heard the learned counsel for the respective parties. This court find that the Honorable Supreme Court in the judgment dated 13th May 2025 has categorically stated that if any illegal migrant as on date in any of the prison within the state of West Bengal who has undergone the entire sentence and is still confined in any of the prison past 3 years from the date of completion of his or her original sentence, he or she shall be released subject to conditions as recorded in the order dated 13 May 2025. Considering the above, this court finds that the petitioner is convicted by an order dated 3rd of May 2017. And since then, the petitioners are in custody. The petitioners have completed their sentence in their 2017 itself. Now we are on 2025. Admittedly, the state has not made any provisions for detention, correctional home / detention center for the illegal migrants. The petitioner has furnished the details of the persons. If the detailed address of the person, if the petitioners are released from on bail, the petitioner will reside in the said address. The same as verified by the police authority, state authority, and state authority submit that the details submitted by the petitioner is genuine one.
Even if this is in isolation rate, keeping good order, was he also provide verifiable by us?
Full stop. The DSGI further submit that. ASGI further submit that. ASGI yoga sab jagah, huh? ASGI further submit that if this paragraph 17 is taken into the isolation, but clause B is specified as per clause B of the said order. As per clause B of paragraph 17 of the said order, the FRRO is required to verify the address. Full stop. This court, the petitioner has forwarded the address to the state as well as the FRRO. But the state has submitted the report, but the FRRO has not submitted the report for the last 2 dates. This court cannot sit tight over the matter only by watching that the FRRO will submit the report. If this court has given any work to the authority has to execute the work. But till date, the FRRO has not submitted the verification report of the address furnished by the petitioner. Accordingly, this court has no other alternative but to accept the report of the petitioner. And the petitioner is released on bail, subject to execution of bond with 2 sureties of rupees 1 lakh each of the Indian citizens, he or she, both the petitioners shall furnish their address to the local police authority as well as to the FRRO within 24 hours from the date of release from the correctional home. Number 3, biometrics of the petitioner and all 10 fingerprints and photos shall be captured and stored in a secure database before release from the correctional home. The petitioners shall report once in every week to the local police station where the petitioner will reside, and local police station specified the FRRO as well as where he resides. Full stop. The petitioner shall notify any chance of his change of their address to the specified police station. Full stop. A quarterly report to be submitted by the superintendent of police within bracket border to the foreigner tribunal is not the FRRO, to the FRRO, regarding appearance of such release declared by the foreigners to the concerned police station, and in case violation of the conditions, the petitioner shall be apprehended and will be produced before the judicial magistrate. But there is no tribunal. Corner tribunal is there.
Tribunal is there.
SP border বলতে তো মুশকিল।
But the first part has to be cooperative.
To the jurisdictional magistrate, to the jurisdictional magistrate for appropriate action.
Yes, order.
And I
আছে কিনা আমার জানা নেই।
in the event any of the conditions are violated.
That is the last.
Cancel.
That is the last. Quarterly report be submitted by Superintendent of Police to the FRRO. Appearance of such release declared the foreign concerned to police station, and in case of violation of conditions, the foreigner shall be apprehended and produced before the landed magistrate, judicial magistrate.
Fine. But where will the bond be executed? That has
Before the surety bond shall be accepted by the trial court with the surety bond, if any furnished by the petitioner, shall be with the satisfaction of the trial court. Surety bond.
and my lord,
SP border
the child my lord,
আছে বলে সত্যি আমার জানা নেই।
liberty may be given.
So you go ask the police, and the police will accompany you to bring the child. That is not here. Where is the prayer? Where is the prayer? If it is problem, then you come second. Petition is disposed of.
One line is added in the so that he doesn't have to file a
SP border বলে কিছু আমাদের নেই কিন্তু।
Already this order will not prevent the petitioner to give a fresh address and it will be verified.
act upon that.
That the court has to study, how the authority will act upon.
In the local police station ওটা ঠিক আছে।
Verify, you come with the court.
Because when these persons, they do not have any money.
What can be done? So many concession cannot be given.
Get
That's a
I'm grateful.
এটাও ডিসপোজ অফ
And not a short point of law, but a very interesting point of law. Lord will remember in the old days, 167(5), time limit to complete investigation. This is that issue. So
what is the section?
The story is this: there was an engineer in the hills, Sarva Shiksha Abhiyan. Money was given that was supposed to be used for schoolwork. The principal accused in this case is a man called Lakpa Rindan. From 2006 till now, I do not have instruction, but till 2010-11, he was never touched. Now, in that particular case, like we have interns in court, my lord knows when you're studying, you come and work. Like that, there were a group of boys. This petitioner, Pranit Rai, he was then in college. He was doing internship over there. The modus operandi of the crime was Lakpa Rindan used to, the allegation is he would make out self-check and he would send someone to the bank. The money would be picked up, brought and handed over to him. That money vanished. So 467, 468, 420, 409, prevention of corruption, everything against Lakpa Rindan. Lakpa Rindan was a government officer who vanished. No sign of him. This boy, along with the other interns, they were sent once in a while, go and bring food, go and do this, go and... So this boy one time was sent to the bank to take the self-check. And self-check, my lord knows, you have to sign on the back. He signed on the back, he collected the money, handed it over to Lakpa Rindan. This is the case against Pranit Rai. This proceeding started in 2006. 20 years, that boy is now 45 years old. His career was destroyed.
Charge sheet filed.
Charge sheet submitted. The joke about this matter was, there is a peculiar issue of law. Now this, I'll just show you, this will make it very clear. Files and everything else we'll come to later. What is important is here. So the FIR is lodged 23rd of May 2006. On 8th of June, 3 boys were arrested. On 9th of June, 3 others arrested. I surrendered voluntarily on 11th June 2006. I was granted interim bail after 1 month in custody. That was confirmed in September 2006. September 2006, prosecution made a prayer for adding PC Act. Now, my lord knows, special case, the special court will act as a magistrate's court. Now, the prosecution prayer is allowed. It became a special court matter. It went to the special court. Now we are to see 167(5). If my lord will just take the CRPC for a moment. Yes. Now my lord will see 167(5), the West Bengal amendment. So 167(5) has been amended many times for many different states. But in West Bengal, it is very interesting because earlier it was only for summons case. Even in Andamans, we had separate amendment was there. But for West Bengal, the amendment is much wider. So the West Bengal amendment says, in 167(5), the following subsection shall be substituted. If in respect of, number 1, any case triable by a magistrate as summons case, the investigation is not concluded within 6 months. 2, any case exclusively triable by a court of session or a case under Chapter 18 of the IPC, investigation is not concluded within 3 years. Or any case other than those mentioned in 1 or 2, the investigation is not concluded in 2 years. From the date on which the accused was arrested or made his appearance, the magistrate shall make an order stopping further investigation and shall discharge the accused, unless whatever.
Correct.
Now, this part, at that time when this matter was filed, perhaps 2009, initially when this case came to us, my learned senior, our learned senior, he was not sure also whether this will be category 2 or 3. Because my lord considers, number 1, summons case to goes. Number 2 is a sessions case. Number 3, any other case. Now, whether this will be sessions case, because this is a special case. So, while it is before court of sessions, pre-cognizance at this stage, it is actually a magistrate situation. Because under the law, the sessions court is a special court, but you are acting as a magistrate. You have the power of remand, you have all the power of the magistrate. Now, so this could be argued in two ways. One way I can say is, if it is coming in category 2, that is a sessions case, then 3 years. But if it is not exclusively a sessions case, because it is a special
Or
case,
any other case.
then it will be 2 years. So now the first question is, will it be 2 years or 3 years? Now, kindly consider, it has to be from the date of the first arrest. Now, in this case, the first arrest happens on 8th June 2006. Ramesh Thapa, Biren Thapa, Bijoy Thapa.
8 June.
So,
Yes.
so if I take 8th June 2006, that means 8th June 2009 if it is 3 years, and 8th June 2008 if it is 2 years. So far I am concerned, I voluntarily surrendered 11th June 2006.
11 June.
So very minor 3 days difference. Whatever it is,
Months, yes.
let us take June 2006. Now kindly come to serial number 9. Now 23/5/2009 is 3 years period from the date of FIR.
Correct.
But there's a mistake here because the law says date of arrest.
Arrest.
So I will ignore 23/5. Now on 28/5, investigating agency files a prayer saying let the investigation be extended, which doesn't exist. But the court says permitted extension. No grounds, no reasoning. Now, this is the point of time when we took out an application under 167(5). And we said, going by the calculation of 3 years, the time is up in June. Going by the calculation of 2 years, the time was up 1 year ago. So you don't have the jurisdiction here to extend. Why? Because you are the magistrate. So the CGM, anyway, had no authority to pass that order. If the order had to be passed, it should be passed by the special court.
Correct. But 8 June 2006 is the first arrest.
8 June 2006
is the first arrest.
So let me take 2 years.
2 years. So
Then
2008.
2008, the time was long over.
And it is not a sessions tribunal.
It is a special case. Only PC Act 13(2) makes it a special case. Otherwise, 420, 406.
So what has happened to the special? What section has been added?
13(2).
13(2). 7 years.
So even there, the problem is we are not government officers. We are interns. The government officer is a principal accused. That is a different issue. I am not appearing for him. Now, this boy at that point of time was not a government officer. He was given a designation as some sub-assistant something, where he was working as an intern. He was still in college, admittedly. So,
what is the actual post? How he has come in the department?
As an intern.
Intern.
In the FIR, he is described as a sub-assistant engineer. Sub-engineer.
By appointment letter is
No
there.
appointment.
No Caesar.
Now, the catch is this. They say that extension is allowed. 3 months after that, they file the charge sheet. Cognizance is taken. After the cognizance is taken, my prayer is rejected by the magistrate. And how the magistrate rejects, my lord will see. He says only, now he extended the investigation time. That time he had jurisdiction. Now he says, no, this is special case, I don't have jurisdiction.
How he can extend that?
So that order we challenged in revision. Now in revision, the sessions judge has passed the order which we have impugned in the CRR. Now my lord will kindly take the CRR for a moment. So first of all, I would beseech your lordship to kindly come to page 34. This is the background of the case. Now the law, again, there is a problem here. At that time, different judgments came. But the evolution of judgments was this. Initially, the court said, and this court said, that in a situation like this, 167(5), the law says you must stop the investigation and discharge the accused. But then the debate started. What if you have got some material? So then the law started evolving. Finally, in 2012, the law became that you cannot automatically discharge. There is no right of automatic discharge. But you cannot consider the material connected after the cutoff date. This is the law. You agree? So we have no difficulty. Up till the cutoff date,
So-
whatever is there,
So
you consider
till June 2008, if you go by
2 years,
2
till
years,
June
what are the
2000.
document they have?
This is the
That is the law.
And so far as this boy is concerned, as far as my instruction goes, there is a check. He signed on the back of the check. He took the money, handed it over to Lakpar. This is his involvement. For that, the process has been worse than any punishment. 20 years, this boy, we have made applications, it is on record. He had a foreign scholarship, could not go. Career went. He was in jail for 3-4 months.
Why you not press the application earlier?
So many times, my lord will kindly see the orders. I've argued this matter so many times, but just by my luck, it was not. My lord, the reason I came and troubled your lordship is because now he has had one offer, he will go abroad. Because of this, he cannot.
Okay.
So if
what
your
about the
lordship,
other accused persons?
the others, I think out of them, the other 5 boys are all same intern category.
No,
The
but
government officers, as
because
per
the
my instruction,
trial is stayed.
yes.
Total
Justice Kanwaljit Singh Ahluwalia at that time in 2012, he said, nothing doing, you cannot proceed like this. That time, in fact, your lordship will find there's an order saying fix the matter for final hearing. As far as this boy is concerned, he is the best witness. That he can say that this man asked me to pick up money and bring to him. Because there is no evidence that this boy received money, that the trail has come to him. Nothing. It's one check which is signed on the back. This is the case against this boy.
So if you sign the bank, so he has received the amount.
He has received the amount and handed it over to the
handed
principal.
over, that is your defense, no?
My lord, that is true. That is
This is
true.
your defense.
That is true. That is true.
Defense how in
No, my only thing is if your lordship sees the charge sheet, the fact that he has handed it over, that the money was with Lakpar Rindan is not in dispute. Lakpar Rindan, as per my instruction, has never been touched. I don't know if he has been arrested recently or not.
he has not been
From 2006 till now,
But a proclamation attachment was issued thereafter, my lord, he is.
20 years, the man has not been touched. 500 crores.
where he is. No.
Sarva Shiksha Abhiyan money.
What you will do
gone.
if this will proceed?
Or it has been stayed by the Honorable High Court.
No. If suppose today the case is dismissed and trial, what you will do with the trial?
My lord, well,
So those 6 boys who
What
were
will be the
arrested,
fate of the trial?
they are
If the big fish has gone,
that is true.
so small fish
But it is part
only
of
for the
my lord,
purpose of oil.
fish example, we understand. He does.
He doesn't. Yes.
Now, my lord,
Yes, there
page
is a-
34. This is the FIR. So the FIR is lodged on 23rd of May 2006, 420, 467, 468, 471, 409, 120B. The time of occurrence is from 2004 to March 2005. The principal accused, your lordship will get in the middle of the page, Lakpar Rindan, WBCS, West Bengal Civil Service Officer. Ex-Education Secretary, DGHC is Darjeeling Gorkha Hill Council. Council Project Officer, Sarva Shiksha Abhijan, posted in Collectorate, DM Office, Darjeeling. Then Bishan Thapa, Ramesh Thapa, Pranit Rai, SAE. This is Sub-Assistant Engineer. All staff of SSA, Cell, DGHC. BB Chetri, S. Mia, all branch managers of Darjeeling Cooperative Bank, Darjeeling. Misappropriation of government fund, sorry, not 500 crore, 5 crore. 5 crore, 14 lakh, 50,000.
5 crore.
5 crores.
112 checks, my lord, altogether.
But this boy signed on one check. This is why I'm saying
What is the amount?
The amount of
One
suffer-
check?
3,75,000.
3 lakh 75,000. And in fact, may I say this also? This boy at that point of time had said, I'm willing, if you think I've taken it, I'll repay it.
Well, the QEDB has said that this is the signature, my lord, which he has.
No,
signed
I'm
on
not
the-
denying. That is a problem. That is the problem. If we have to go to trial, that's a different issue. But I'm saying honestly, the money, this man did this. And if I say, your lordship will be surprised. Even in the High Court, when we practiced, in the old days before we had all these UPI and all, when we needed money, no advocate stood in the bank. The clerk would go, he would do it, and this is the way. Page 35 is the FIR. Darjeeling Gorkha Hill Council. A case of fraudulent drawal and misappropriation of fund from SSA DGH account number so-and-so maintained with DCCB Darjeeling has come to our notice. This drawal of fund relates to the disbursement of fund under Sarva Shiksha Abhiyan for construction of new school building, water, toilet block in 102 schools construction of additional classroom in 90 school, and the total fund involved is 5,14,50,000. It appears that this fraud has been committed with the collusion of ex-Education Secretary L. Rindon, staff of SSSL, namely late Dilip Kumar Rai. He was a cashier. Bishan Thapa, Bijan Thapa, Ramesh Thapa, S.A. Pranit Rai. These were the interns. There appears to be collusion between these officers and staff with the branch managers of DCCB Darjeeling, namely DM Tamang, VB Chetri, S. Mia. The fund has been fraudulently withdrawn and misappropriated from available SSA funds in DGHE starting December 2004 up till March 2005. This fraudulent drawal of fund has taken place from the current account number 641 of District Central Cooperative Bank, Darjeeling, with the involvement of the ex-Education Secretary, DGHC, and Council Project Officer L. Rindon, Branch Manager in charge of DCCB Darjeeling, DM Tamang, Manager S. Mia, BB Chetri, and Council SSA staff, late Dilip Kumar Rai, Bishan Thapa, Ramesh Thapa, Bijan Thapa, Pranit Rai. It appears that the aforesaid persons in collusion withdrew an amount of rupees 514.50 lakhs from DCCB. We did 30 checks drawn at different dates on the same account, received the amount entirely in cash, but there is no trace of this amount having been officially disbursed to the alleged VEC WEC. Late Dilip Kumar Rai, who functioned as cashier in SSA cell, and others received the cash amount as per the enclosed statement of the bank. Dilip Rai, cashier, expired on Atho. Rindon has been transferred since March 2005, presently posted in District Magistrate Office, Darjeeling, and they could not arrest him. To detail the matter further, the following sequence. Now the entire sequence is there. Everything, kindly see number 2. The writing on the check is of Rindon. During the period starting 4 September 2004 up to 23rd March, a total of 30 checks were self-drawn by Rindon. The entire amount withdrawn in cash by either one or the other signatory from SSA cell along with Rindon. Only 4 checks were credited to the account, which was duly transferred to the account. Then kindly see again 3. All the money that was supposed to be used for the building, it was enhanced and dealt with solely by Rindon. Kindly see the next page. During the above stated period, files connected with this matter was dealt solely by Sri Rindon to process for grant of funds for construction of 102 new school buildings. All the cost is there. It is unknown as to why the amount granted for new school building, which is normally granted at 3,50,000, was enhanced to 4,50,000 by Sri Rindon on his own. From the office records, we have retrieved the bills which were prepared in favor of President Secretary of VEC WEC. As seen from the above records, no amount was ever handed over to VEC or WEC, either in cash and of course not by check. The cash book available in SSA cell is left completely blank during this period. No record as to any cash withdrawal or disbursement of the amount has been kept. Due to the death of cashier Dilip Kumar Rai, it is difficult to ascertain as to why this record keeping was not done. There is no authentic record indicating in whose favor or to whom was this cash withdrawn from the bank, disbursed or handed over. These entire transactions came to light when the audit conducted by senior auditor from the Office of Principal Accountant General Audit dated 17/11/2005 gave adverse comments regarding handling of SSA funds, particularly the non-submission of utilization certificate relating to civil work, following which this office asked the respective WEC, VEC for submission of utilization certificate for the fund purported to have been credited in their favor by account payee check from SSA fund. There was a complete denial from all VEC, WEC for having received any fund from SSA for construction of new school building or additional classroom. All the above actions appeared to have been taken by Sri Rindon, the then Secretary, Education Department and Council Project Officer, SSA DGHC, without approval of either Principal Secretary or Empowered Councillor or Chief Executive Councillor. Now I am directed to lodge an FIR and request a criminal case of cheating, forgery, fraudulent drawal, misappropriation of government fund may be initiated against Lakpal Rindon WBCS. Under the relevant provision of law, suitable action be taken. Lakpal Rindon is a WBCS officer presently serving in this. Similar action may be taken against other staff that are engaged. We were the collateral damage.
Yes.
In fact, throughout this, the allegations were Rindon did this and these young boys were used as the means to collect the money. So I was lucky it was only one check. Page 39 is the charge sheet. No matter what we'll find, others have been sent regularly. Page 39 is the charge sheet. Here your lordship will get para 12, Ramesh Thapa, Roman 12, date of arrest 8/6/2006. So that was the first arrested accused. Thereafter, the charge sheet is submitted with PC Act against a total of 8 persons. Ramesh Thapa, Bishan Thapa, Bijoy Thapa, Bir Bahadur Chetri, Dharman Tamang, Shering, Suraj Mia, Pranit Rai, Lakparindan. Now kindly sees the order sheet. So the order sheet of the magistrate's court, my lord will find it is kept there loose. Because we were not getting the certified copies, so that is why this has been obtained subsequently. May I just hand up a copy to your lordship? Now this tells us the story of the dates. So April 2016 FIR, then the first arrest and remand is at order number 3, 9th June 2006. Ramesh Thapa and all were taken into custody and brought. Then my lord will see 11th June 2006, order number 5. Accused Pranit Rai is brought under custody, being arrested and forwarded by court inspector. He is taken into custody, remanded to JC till so-and-so, forwarding letter, etc. Thereafter, he remained in custody for some time. All the other accused were arrested.
Where is the impugned order?
The impugned order, I am coming.
Where is the date of cognizance? Charge sheet?
Cognizance, my lord, is 12/8/2009. My lord, this is the impugned order before the magistrate.
Yes.
It is order number 45 dated 27th August 2009. Accused 1, 2, 3, 4, 5, 6, 7 on court bail are present by filing Hazira. Copies are ready. No ER of warrant of arrest has been received against accused Lakpa Shering Rindin. Issue reminder to 9/10/2009 for ER of WA. Learned advocate files a petition in regard of accused so-and-so, so-and-so. Prayer for stop investigation under 167(5) CRPC on behalf of accused to discharge the accused. Peruse the record, connected papers thereto. Heard learned counsel considered. Section of law involves exclusively triable by the Court of Sessions. I have no power to entertain. Hence, the petition is rejected. So 167(5) was rejected. In the bundle that I have just handed up to your lordship of orders, in that bundle, my lord will find this is the order dated
Which one?
I'll just show you.
What about
Order
the other
number
accused?
42.
Huh?
Order number 42, 28/5/2009.
28/5. Yes,
Filed a prayer from IO of this case for extension of time. Prayer is considered allowed. One line. Now I don't understand. If the CJM has power to pass an order to extend the investigation, why does he not have the same power under 167(5)? He declines, saying this is a matter for the special court. Now my first submission is this is an illegal order without jurisdiction. Because the minute PC Act sections were there, the CJM had no power to do anything about the investigation. Now, having done this and extended the investigation, he ought to have considered this.
When the PC Act invoked?
PC Act was added on?
June 2008.
No. The prayer is on 1st September 2006. Prosecution made a prayer for adding PC Act. It is again in this bundle.
1st September 2006.
1st September 2006. This is order number Order number 25, 2nd September 2006. Seen the prayer of Inspector so-and-so adding, since CD has already been called for, put up on 4-9 for considering the prayer. Then the prayer is considered. Next order 4-9.
For considering the prayer.
And then at the next page, bottom, since CD has not been produced on prayer of APP, fix 18-9 for hearing IO's petition for adding section this.
CD enough ingredients. 18 September.
Then the next order is 18-9.
18 September. It was
So prayer for adding aforesaid section is considered.
So once the PC Act is added, whether the magistrate having the jurisdiction to retain the file?
No.
Because
That
earlier
he, the sad thing is he realized it when I made the prayer. He has to send it.
once the PC involved, because earlier there was a confusion.
Yes.
Justice Pasayat.
But then after that, that was cleared in 2008. So
Justice Pasayat order 2-3
my
orders were there. Then
it automatically has to go, and
has to
then
go.
the special court will act
has
as a
to
magistrate.
take the cognizance and as a magistrate and take
And then
cognizance,
take
issues
up
need to notice.
So here was the first mistake. Now this mistake prejudiced me because the extension of investigation could not have been done.
And after this, he has passed an order for investigation.
Now my humble submission is perhaps the fairest.
I have that judgments. I think because my touch-up has gone.
Everything. That is why we need your lordship to come back to criminal side.
My touch-up has gone from the criminal side. Ajit Pasha, I remember that. 2-3 orders, there were contradictory orders were there. Then it was settled that no.
So that is why I'll show your lordship the judgments. But to be very fair here, perhaps Mr. Sinha will say the same thing. What needs to be done is, number one, on the materials, if that check is the only thing, then on merits, this court can invoke 42 and quash. If there is no other material. But even in a worst case scenario, let me assume, what the magistrate should have done was in 2008, when the 2-year period expired, it should have been with the special court. The special court would not automatically discharge. He will call for the record. He'll go through the record. He will see what is there against each accused. If nothing is there against the accused, then he will discharge. This is the law. And that there is, I don't think there's any doubt about it or any conflict about that. So here, let me just show your lordship.
No, that I am thinking this way. If on 18 September 2006, he has invoked the PC Act added. So he lost his jurisdiction. If he lost the jurisdiction, the extension has gone. Once the extension has gone, the 167(5) come into play.
So that is the difficulty. The 167 came into play in 2008.
Correct. That's why.
But he lost jurisdiction in 2006.
See, that's why.
One should never have been dealing with this
jurisdiction, so he cannot extend the time. If he could not extend the time, the investigation could not even complete.
Could not have proceeded, which means the charge sheet is the fruit of the poison tree.
Okay.
So this is the, in fact, this is the backdrop of the case. Now, if your lordship kindly sees the impugned order. It's not paginated, my lord, because certified copy.
I am having certified copies there.
So here, the learned sessions court goes through everything. Decision with reasons is one paragraph. To appreciate the point, I have meticulously gone through the record. It spells out therefrom that the incident's case is triable by special court. From the order number 44 dated 12/8/2009, it further emerges that cognizance taken by the learned court below on 12/8/9. It also revealed that on 28/5/9, before the expiry of 3 years, the investigating officer made prayer to the concerned court seeking extension of time for completion of investigation, which was allowed by learned court below during the extended period so granted. Charge sheet was filed on 12/8/2009. There are 3 huge mistakes the court is not realizing. Number one, that if this cognizance is taken, it's bad in law. Because the court taking cognizance is not empowered to take cognizance of PC. Number two, that the expiry of time was done, again for the same reason, is illegal. And number three, that the charge sheet is filed, is that the charge sheet is on the basis of an illegal investigation. The charge sheet goes. 3 things the court did not realize. And then says, after giving my anxious consideration to respective submissions of the lawyers, that section so-and-so as amended is not at all applicable to the fact situation of the case where the investigation had been completed. Charge sheet has been filed within the extended period granted by the learned court below. Therefore, it is crystal clear there is no illegality.
When the case is committed to the special judge?
After the cognizance was taken in 2009, so immediately thereafter. I have some doubt, in fact, whether it was committed. Because the High Court stayed the proceeding. So whether it was committed also, I have some doubt.
Where is the case is pending?
Till now, my instruction is CGM.
How?
File was never sent. They're still waiting to catch Lakpar Indian after 20 years.
लोअर कोर्ट रिकॉर्ड आया है क्या?
Record have been called for तो LCR.
लोअर कोर्ट रिकॉर्ड है क्या? कोई और रिकॉर्ड है उसमें? नहीं, LCR नहीं है. LCR is not called for. LCR is not called. না, আসে না. So what is your contention?
Lord, my contention is that whatever Mr.
No, see now whatever the application now, this court has observed.
That
If
under
August
2006 he has lost the
2006 when he has added the PC Act, whether the magistrate can continue with the PC Act in his file. First thing. Second, whether he can extend the time for investigation, so PC Act has been involved. Third, the cognizance taken by the magistrate can sustain in the eye of law under the PC Act.
But my lord, so far as the investigation, if at all for 2 years or 3 years, Roman 2 or Roman 3, whatever has been done during that time, your lordship can consider that. That is the law.
Now that can be, but now the PC Act is involved.
I understand.
Once the PC Act, so cognizance itself is wrong. So 167 need not to look into.
I understand.
Need not to look into.
But I will have to go through the.
So in the so I am calling for the law the LCR. TCR I am calling, not LCR nowadays. It is a TCR.
Yes, now you can't.
Now it's a TCR.
In the meantime, my lord, I will also go through the entire order sheet, and it's a huge case diary. My lord, your lordship has seen.
No,
I will prepare a
case
short note.
diary. Yes, so not case diary. Only these are the 3-4.
I understand. The question of law.
If at all, okay. If we presuming that the
Supreme Court,
it is okay, you extended your file. So 2 years is to be taken or 3 years is to be taken. Because other case 2 years.
Yes, other case 2 years.
Other two, so special case is coming under the 2 years. It is not a sessions case. If it is a PC Act, so it will be a special case. So special case cannot be converted and taken into consideration as a special case. Sessions case. It is to be taken as a special case. So if it is taken into a special case, so it has to be taken as a other case. That is also
Roman 2.
3. Roman 3.
Roman 3.
Roman 3. 6753. Take, and I am calling for the TR. Learned counsel for the petition argued the matter at length. This court find that for adjudication of the present application, the trial court record is required to be produced before this court. Accordingly, department is directed to call for the trial court record of what is FIR number? Of FIR number 31 of 2006.
31 of 2006, 23/5/2006.
2006 under section 420/468/471/471/409/120B IPC of which PS? Of
Darjeeling.
PS Darjeeling Sadar and PS Darjeeling Sadar and pending before the Learned Court of
CGM
Darjeeling. CGM Darjeeling. Before the next date fix. So February I am fixing because record has to come. Let them give the February middle any 2 p.m.
My lord, can it be on 17th February? And my lord, my humble prayer, kindly keep it part. The matter has been heard out in great. My lord, from 2012 I'm trying. So many honorable judges heard, retire, heard, retire. Now I will not let that happen this time.
Due to the parted, this court is overburdened.
No, my lord, I will not burden your lordship. My lord can be sure of that. Next day when I come back, I will come with two things: short note and judgments.
That's why it was.
That's
Because
all.
you also take. These are the 4 points.
There is nothing
because
more. This is
Whatever else
the
wanted from your lordship.
Because he is admitting with regard to the one check, signature admitted, GAQD report is there. So this court at this stage.
Actually, there are.
So not. So,
but apart from that, there is
that's
nothing
why.
else.
Apart from that,
No,
you
but
see.
the only thing is that if he is admitting that he has withdrawn 3,75,000 with signature is of him, my lord, factually whether these are defense points. My lord, these are for trial. He will have to prove.
No, that's why I told you. If he is admitted, then the trial, then the DWs come.
No,
He has to.
the problem here is my admission is to this extent that this is my defense case. Now, at this point of time, if my lord considers 420, 406, all of these, there are ingredients. Now, if a part of the money has passed through my hands, let me accept. It does not complete the chain.
Correct. That is
So,
different.
if you have one
Connivance.
thing, you do not have the offense.
Whether he is an intern or he is an assistant engineer, it's a question of fact.
Okay. 17 is खाली है. 17 February खाली है. 17 February at 2 p.m.
My lord,
As a
specially fixed.
as a
2 p.m.
specially fixed matter.
My lord, Parker.
I will take.
My
Don't
lord,
worry.
kind.
Don't worry.
Kind, only
Perhaps-
this much I am requesting your lordship. I am beseeching.
Parted kori.
Deep.
Yes, next.
Deeply obliged, my lord. Very great.
When you are returning.
Because our circuit is also good. Deep.
Item number 18, appear for the petitioner.
Yes.
Here, my lord, we have
Yeah,
challenged.
Opposition.
I want to reply to. But I have also prepared my reply. My lord, I'll file it.
Yes.
My lord, this is here. My lord, we have challenged the decision of the railways to impose liquidated damages while refixing the delivery period. My contract has not been terminated yet. But supply order, I'm told my reply has been filed. Supply order, railway tenders.
Let me see. Yes, it is here.
It is there.
Where is the impugned order?
The impugned order, my lord, the order, the decision of the railways, which
Objection is that malad, this is out of jurisdiction, malad. That is inverted page 75, malad. This is occurrence Mumbai, malad, not the university. Kindly come to malad.
Okay, let you satisfy with
Yes.
regard to maintenance.
the jurisdiction, very well.
Page
But,
75, malad.
Yes.
Clause 37, malad.
Jurisdiction
Of the
for
court.
any
Or-
dispute related to contract inspection, RDSO, general guidance or vendor approval, any dispute pertaining to the tender, the court of jurisdiction, headquarter concerning railway, Delhi, from where the contract has been issued. Yes.
The contract has been issued outside malad, West Bengal, malad. Respondent also, malad. All the respondent is malad outside West Bengal, malad.
Where the work is to be executed.
That is malad,
What is the supply? Supply material, supply of materials.
Yes, supply of
What are
materials,
the materials is to be
that
supplied?
is Western Railway, malad. Mumbai, malad.
Mumbai. No, where is to be supplied? Materials
Supply
to be
Northern Railway, malad. Under
Northern Railway, whether it is including the West Bengal?
No, malad.
No.
No, nothing, malad. Their intention that some proceeding has been through mail, malad, through mail and bank, other bank
Correspondence.
transaction. That is West Bengal, but this is not.
Bank transaction means amount deposited, the PC deposited here, performance guarantee.
but I'll tell my lord. But I am led by Mr. Banerjee.
So that is
PG deposited here.
Yes, but bank guarantee.
Bank guarantee deposited here.
I think so.
Deposited in Calcutta.
Not deposited at malad, Mumbai office.
Which bank?
That is.
Yes, Mr. He has raised a valuable point of the jurisdiction.
Let him address your lordship. But I had a slightly simpler possible solution to the case. Well, initially when we came up, they were not accepting our goods. They were not extending the period of delivery. After we filed the writ petition, they have actually accepted the goods. And for part of the goods, there is a new notification that has come up by RDSO, where the goods that I actually manufacture, the modalities have changed. So they can't accept these goods. So that part of my case is gone or accepted, either way. What is remaining is imposition of liquidated damages on the same principle that I was addressing, Your Lordship, on the last day, that without actually suffering a loss. Now, my Lord, this entire exercise can be cut short if they give us a hearing, because now that they have accepted the goods, so the entire dynamics actually change. They can just give us a hearing and pass an order as to whether on these aspects. My writ petition can be considered a representation.
So you will get the jurisdiction in Bombay, call them
Wherever, then he can do that.
That can be, my lord.
But it can be
But Your Lordship, can you give some time that I'll take some instruction, my lord.
If you accepted the materials,
Yes, ma'am.
if you accepted the material liquidated damage, sit together and
Yes,
decide
yes,
that.
no problem.
That when? How
1
much
week,
time?
my lord.
Bombay, get it phone over.
I'm outside.
If he takes instructions from here, it will give me jurisdiction.
That is good part. 1 week time, my lord. 1 week time.
So there is an interim order which is there, kindly extend that.
The petitioner submits that petitioner has filed a representation before the authority for consideration of the request of the petition request with regard to the liquidated damage imposed upon the petitioner. Full stop. Counsel for the petitioners and respondents press for time to take instruction. Accordingly, cases adjourned. Let the matter appear on. एक तो डेट दिन देखो अर्जेंट मोशन में कौन सा खाली कम है
21st, 22nd, any day.
जनवरी देखो है कोई
22nd,
कम
मतलब?
मैटर वन जिसमें कम मैटर हो
That will be hard to find. That.
29 जनवरी कितना मैटर है 29 जनवरी
2 PM,
under the same heading, under the same heading, urgent motion. Urgent motion. The interim order is extended till 3rd February 2026 or until further order.
Opposition may be kept.
The affidavit in opposition filed by the petition respondent be kept.
No, reply কোর্টে জমা দিয়েছি তো
Reply jama.
Yes, reply is on record.
Grateful. Deeply.
Next. Call. For call for.
24. On 24th December 2025, the matter was taken up. This is a case of without Mental Health Act 2000.
That one.
That one.
Board is not constituted. There's some order was passed, no?
Yes, my lord. The order was passed. There is a direction upon the respondent's
Yes,
state.
Principal Secretary, Department of Health and Welfare is directed to submit the clarification or by clarifying with regard to the constitution of the board in terms of section 74 of the mental within the Calcutta. But what has happened?
My lord, they have not contacted with me, my lord, but they are supposed to appear today. Matter is under the hearing urgent motion. Let this matter come tomorrow, my lord. I shall serve notice.
Okay, not today, inform the.
My lord, last occasion I have Mental Health Act, Where Act, my lord.
Fair Act. Might be here.
Not this one. Smaller one.
Okay, my officers will check and it will. Yes, next. Not today. Huh? Next. Call. First.
26. 27.
Your Honor, kindly give not today.
Not today. 29.
Lordship, I appeal to the petitioner. Lordship, on the last occasion, Lordship had indicated that the order will be passed in this matter. This regarding the IVF matter.
Yes, yes, I will see. You. Yes, what is the age of the petitioner?
Lordship, the petitioner is she's she's 47 years old, Lordship.
Petitioner number one?
One is 47 years
The
old.
wife.
She's the wife. And
The wife is the 47 years.
yeah.
And husband?
Husband is 58 years. Lordship.
50.
58.
58. So over age.
Yes.
And she is the 47.
Yes. Lordship, the
Okay.
ceiling for the wife is 50 years.
Two.
So
50 years. 50.
And for the husband is 55 years. So he has crossed it by 3 years, but the wife is well within the ceiling limit, Lordship.
So you are having children?
Lordship, my son expired. Lordship, I have another child who is retarded. Lordship is got some difficulty. Those averments are made. Lordship, I have made the express averment that in case Lordship directs that I have to use the sperm from the sperm bank, then I shall do that. There'll be no involvement of the petitioner number 2.
You will import outside.
Lordship, because if your Lordship so directs, I want to, as everybody.
So, you are having 2 child or 1 child?
Lordship, 2 children, 1 child died. And Lordship will kindly take up my averment. Death certificate of the child is at 20 years he has died. It's P4 is the death certificate of my child. It is at page 16, Lordship.
Yes.
Chourav Shatra, my son has expired at
28 years.
Yes, Lordship, sudden demise. He went to give puja to in the temple and he died there.
Then medical report, you had been to the hospital?
Lordship, my medical reports are thereafter page 5, Lordship.
Page?
Starts from page 17.
Yes.
Lordship, all the medical reports I have enclosed.
IVF,
Yes.
adoption, husband age 55. So need permission from the court to go ahead with the treatment. Yes. Eligible for the pregnancy. Therefore, who is for the other side? Nobody.
Lordship, they have on several occasions sought for time. May I most respectfully, Lordship, the circumstances of the parents, Lordship, can understand from the demise of the son that they are undergoing a lot of pain. Lordship, their only objection was on the ground of the Kerala High Court's judgment that the division.
That is settled.
Yes, that is settled. That has been
Record. The petitioner has filed the petitioners have filed the present writ application saying for
My lord, item 29. Item 29, I am for the respondent one. What did it say?
yes. Okay, take rest. Yes. What is your objection?
My lord,
Better.
appeal file is pending, my lord.
Huh?
appeal file is pending, my lord, same issue, my lord.
Ah.
This matter is not maintainable because, my lord,
Huh?
this matter is not maintainable because, my lord, ultravirus is not, my lord, under challenge, my lord.
I am
What ultravirus?
My lord, my lord,
Lordship, there is no prayer challenge.
my lord, kindly keep to, not today, my lord.
I am disposing of.
My lord, I am asthma patient.
Huh?
Very difficult. I am asthma patient, my lord.
Huh?
I am a asthma patient, my lord.
Okay, no
My lord,
problem, no problem.
kindly not today, my lord.
Why?
My lord,
Have you gone through the division? Our court's order is already there. Have you gone through the Kerala High Court division bench order? Affirmed by the Kerala division bench, affirmed the order of this court as well as the Kerala
actually, my
Supreme
lord,
Court order.
in this, on behalf of Mr. Pathu's appearance of the respondent, my lord.
Correct.
Kindly, he has not come today.
If
Kindly,
he appear or you appear, law will not change. What you are challenging? What is your submission? Why you are objecting for that? Once the court has upheld the order of this court, division bench has upheld, you file an appeal under what ground? There is no stay.
No, my lord.
Then what can be done? Yes. What is your ground? Tell me, so that I can record your submission.
Lordship, I have not challenged the vires of the act. I say that I am well covered. It is only
Correct. They are not
yes.
challenging virus.
There is no challenge to the virus.
They are on that the husband is overage, wife is within the age. So one child, there were two children. One child is died. One child is having some problems. So they want the another child. So husband cannot go. The wife wanted to go with the IVF. And doctor has given the report that she is capable for conceive. That is the only thing. So this court is binding by the order of this coordinate order. What they have not challenged with regard to 2G. They are not. Their prayer is not that the husband may be allowed. So and this court is already espoused. It is not necessary that both the spouses to be this age under the age of 2G. Correct.
Yes, ma'am.
The petitioner has filed the present writ application praying for allowing the petitioner number 2. Petition number 1. Allowing the petitioners to approach an assisted productive technology clinic for obtaining the services authorized of the clinic for the purpose of employing assisted productive technology services in order to conceive a child. Full stop. The petition number 1 and 2 are the couple. Out of the marriage between the two, petition number 1, out of the marriage between the petition number 1 and 2, one male child was born on 17/4/2024, namely Sayandip Tantra, and another child. What is the name of the another child? Was born. What is the date of the another child?
Lordship, the age of the other child is 18 years. Averment is in paragraph 3, Lordship.
And another
18
child
years, he is physically and mentally challenged.
is full stop. Another child is at present 18 years, who is physically and mentally challenged child. The elder son of the petitioners died at the age of 20 years on 10/12/2024. 10/12/2024, 10th December 20.
Lordship, it will be 28 years. It is a typographical error. It has
Yeah.
gone in as 20. It will be 28 as per the
Died
death
on-
certificate.
Died on 10/12/2024. After the death of Pulisto, as one of the child of the petitioners is a physically and mentally challenged, and accordingly the petitioners challenged, and accordingly the petitioners have decided to have another child. The petitioners have approached the doctor, but it is found that the petitioner number 20, petitioner number 2, the husband is 58 years, and the petitioner number 1, the wife, is the 47 years. And as such, it is not possible for the petitioner number 1 to conceive the another child and another child fully. The full stop. As per the advice of the well-wishers and family members of the petitioners, comma, the petitioner had decided to visit an infertility clinic to have to conduct the process of IVF. The process of IVF. On medical checkup. On 23rd of July 2025, it is found that the doctor has opined that the petitioner number 1 is eligible for pregnancy, but the husband is for 58 years, and as such, and permission from the court is required for further treatment to adopt IVF process. Full stop. The petition submit that the petitioners have been denied with the benefit of assisted productive technology on the ground that the petitioner number 2 is overage in terms of section 21G of the assisted productive technology within bracket regulation 2021. Accordingly, the petitioners have filed the present application. The petitioner has relied upon the judgment in the case of
Sanchita Ghosh and
in
Shamoli.
case of Sanchita Ghosh and another versus Union of India and others, passed in WPA 12154 of 2023, dated 8th April 2024, wherein the similar question arose before this court, and this court has held that in the event one of the spouses is eligible under section 21G and the other is not, comma, it will be at the option of the clinic whether or not to use the gamete donated by the ineligible spouse in the process of assisted productive technology. Full stop. This court has held that section 21G and its sub-clauses read harmoniously with the definition clauses as stipulated in section 2 of the Act of 2021 can give complete meaning and a wide expense to the said act in consonance with the contemplation of the preamble of the act. Accordingly, this court held that provisions of section 21G of the 2021 Act create no unreasonable discrimination between married and unmarried women in availing assisted productive technology, and thus passes the test of constitutionality. ঠিক আছে? The petitioner has relied upon another judgment in the case of Shamoli Shaha and another versus State of West Bengal and others, reported in 2024 SCC Online Calcutta 10379, wherein in the said case also the similar question was arose, and the coordinate bench of this court has held that that the medical report of the lady suggests that she is currently physically fit to hold the embargo, which means that the lady is eligible to avail ARTS both age-wise as well as the health-wise. Full stop. The petitioner has further relied upon the judgment in the case of Union of India versus Devyani S and others, reported in 2025 SCC Online Kerala 11786, wherein the Honorable Division Bench of the Kerala High Court has held that the Constitution of India guarantees equality of status and equality of opportunity to all citizens, irrespective of the fact whether they are men and women, and also that women shall have equal rights and privilege along with men, that the state may make special provision for welfare of the women. Section 8 of the Hindu Adoption and Maintenance Act 1956 was amended to remove the incapacity of the married woman to take in adoption of a son or a daughter merely on the basis of marital status by the personal laws. At the learned counsel for the petitioner, learned counsel for the respondent raised objection and submit that the petitioner has challenged the virus of the act and as such required some time to make appropriate submission in the matter.
Yes, ma'am. The appeal file is pending in same issue.
Petitioner further submit that the petitioners have also filed an appeal against the order of the coordinate bench of this court, and the same is pending before the appellate court. At the learned counsel for the respective parties, this court find that the petitioner has not challenged any virus of the act. The petitioner has prayed for the benefit of the judgment passed by this court in the similar matter. As regard the appeal is concerned, this court find that based upon the honorable learned single judge of the Kerala High Court, relying upon the order passed by this court, the coordinate bench of this court, Supra, the learned single judge of Kerala High Court has passed an order challenging the said order, an appeal was prepared. The appellate court has affirmed the order of the learned single judge, which was passed taking into consideration of the judgment passed by this court as mentioned above. Considering the above, the petitioner number 1 is aged about 47 years. 47 years. She is coming under in the category of 21G. 21G. Full stop. The petitioners have the 2 children. Out of 2 children, 1 child has expired at the age of 28 years on 10/12/2024. The another child is mentally challenged. The petitioners are having capacity to look after the children, and they had been to the hospital to have the IVF process, but IVF process, and the doctor has opined that the petition number 1 is eligible for the pregnancy, but for the said process an order of the court is required. Considering the above, this court finds that the petitioner is coming under the purview of section 21G, as the petition number 1A and the age of the petition number 1 is 47 years. Accordingly, this court held that the petitioners will be entitled to have the benefit of assisted productive technology service and can approach an appropriate clinic for having such services in view of the fact that one of the two spouses, that is the petition number 1, qualifies on the upper age limit as stipulated in section 21G, irrespective of the fact that the other spouse does not so qualify. It is fully stuff. If the petitioner approaches the concerned clinic cell within the contemplation of the act, assisted the petitioners to have the benefit of such assisted productive technology services with or without the gamut of petitioners number 2 at the discretion of the clinic.
I'm great.
WPA number 776.
I'm extremely.
Dispose of. No original side.
The Lordship, may I mention with the kind permission?
Which one? Appellate side?
No.
Original side?
The Lordship.
Please wait.
Lordship. আমি একটুখানি
Yes.
I have kindly leave to mention a matter. I have already taken leave of my learned seniors, waiting for the mentioning because there's a fixed matter which has got called. But I'm mentioning upon notice item 122. The interim order is expiring on the 16th. So, yes.
To be mentioned for
Lordship,
exception
may I
of
be
interim.
permitted to, Your Lordship, may I be permitted to mention this matter? Your Lordship was pleased to deliver the judgment on last Friday, Tanamodishan matter, Your Lordship. What I was only humbly submitting that the name of the special referee needs to be, Lordship, changed because the special referee is representing the plaintiff in some other matters, Your Lordship. So I was humbly submitting that let this matter appear as to be mentioned tomorrow so that
tomorrow
and also a small correction in the order also. Judgment.
Lordship, Your Lordship, I'm mentioning this to seek the leave of the court to get the urgent copy of the judgment, the certified copy, Your Lordship.
Huh?
The copies of the certified copies of the judgment, Your Lordship.
What is the leave is required?
The statutory period for the appeal is lapsed.
Lordship, may I be permitted, Lordship? Lordship, item
Yes,
number
my Lordship.
174 of today's list, Lordship. We are for the defendant number 3 bank. We have already filed an GA of 3 of 26, Lordship, for deletion of our name, Lordship. For deletion of the defendant number 3's name.
Deletion of the defendant number 3. Yes.
Lordship, for application of this matter.
Deletion, when it will come, it will take. What is the urgency? What is the urgency? There are so urgency matter. Please wait. Let the pressure come, then I will take the matter.
Madam, may I permit it to mention mentioning for upgradation, madam?
For what? What is the urgency?
The urgency is, madam, my bank account has been frozen, madam.
When?
It has been frozen in December 2025. December 2025, and I am
December 25.
25.
Yes. Why it has been frozen?
Frozen because, my lord, due to some forensic audit report, which is
Forensic audit report conducted by whom? Bank.
Not bank, my lord.
Ah.
By some other authority, my lord.
Huh?
By some other authority.
Other authority means which authority? So you are involved in the criminal case.
Yes, my lord. I
So you obtain. So you are not went to the trial court.
The trial court I am going, my lord.
What has happened in the trial court?
And I have obtained bail, my lord.
Not bail. If you are freezer, you go to trial court, file an application. The court will pass. Not here.
No, kindly let this matter be heard, my lord. Can
Sir, I am telling you, I will heard. I am indicating you. If it is a criminal matter, in the investigation is going on. In the during the investigation, police has freeze the as per the direction the police bank has freezed your account. So you go to the trial court and make an application for defreezing. If the trial court will not, then you go to the other court. Not this court, not the writ court.
Let this matter be upgraded.
I am giving you advice without any consultation.
My senior will substantiate. My senior will substantiate.
But you are not understanding my advice. What can be done?
I am led by my senior, my lord.
Tell your senior, I am not taking. Tell your senior, the court has stated, let the senior think whether I have given the proper advice or not. Correct. And thereafter, you talk to the senior, what I stated, you understand, na?
Yes, ma'am.
Yes, inform your senior. Yes, call the list.
My lord, in this matter, my lord, I have completed my argument. I have given notice to the other side, my lord. They have to forward their argument, my lord. Let a time and date be fixed.
Yes.
A time and date be fixed with regard to.
In this matter,
Very short matter.
Mr. Prabal Kumar Mukherjee, London advocate, if your lordship, my lord, kindly keeps it any day after 27th.
Who is appearing?
Mr. Prabal Kumar Mukherjee.
Huh?
Mr. Prabal Kumar Mukherjee.
Prabhat Kumar Mukherjee.
27th.
27th, my lord, any date after 27th, my lord.
What is the matter?
The matter is
recovery of money
suit, my lord. We have paid the suit, and no, my lord.
You will get the interest if you get the
It
degree.
is pending for a long time. My lord. We have submitted with our argument. We submitted.
Final argument.
Final argument. Submitted our argument. They will only give reply. They will only give opposition. Then we will file. We'll submit reply for some time. Only a very short matter. March. My lord, I'll die, my lord, not March.
You want the date fixed in March.
My lord, I'll die, my lord.
So you want the matter
my
to
lord,
be
I'll die, my lord.
If you
My
want the
client
matter,
is beside me every day, sitting in my office for this, my lord, very short matter. My lord, only half an hour.
so can I sit? I can decide in sitting in your
My
office.
lord, only half an hour, my lord, any day, my lord. My lord, not March, my lord, will die.
You do one thing, take the diary and check when
Any day, my lord, February. একটা date নেই 28 পরে
My hour I am getting, then you are also taking this resolution, then half an hour, half an hour mentioning 15 minutes, 15 minutes.
March which date?
So you are telling the half an hour where I will.
But not even last week of February. That one. 11 March.
30th February?
Why that?
30th February?
No. 11 March a time we fix, man. Then what can be done? A time we fix.
The matter. Which matter? Item number?
One.
Item number 1. The matter, as per the submission made by the council for the parties, let the matter appear on
at
11 March at 3 p.m.
3 p.m.
As a specially fixed matter. Yes, call the matter.
Lord, in item numbers 2 and 3, I appear for the petitioner. My lord, praying
I
for
beg to appear for the
extension of
respondent.
interim order.
The pleadings has already been completed.
Pleadings of GA.
Pleadings of GA.
Lord, it's a writ petition.
Writ petition.
My lord, I'm praying for extension of interim order. This is your lordship's last
Again,
order.
one thing, my lord. In a connected matter, my lord, the appeal has been preferred by the bank before the division bench, and our appeal has been allowed by the division bench by adding the CBI as party. Well, I think, my lord, this matter also CBI is equal to be added as party.
No, it's not.
Well, I'll indicate.
No, I've let them.
the
Yeah.
matter.
My lord, it's
They
a
have challenged the
declaration.
show cause notice, but they have challenged the show cause notice.
Declaring fraud.
Declaring fraud. Now, my lord, their FIR has been, my lord, the complaint has been quashed by the single bench, coordinate bench of the lordship, my lord, after it has been culminated to the FIR. Bank has challenged the same. Division benches hold that, my lord, FIR cannot be quashed. Now, my lord, in this, it's a connected matter. I will address you, lordship.
My lord, if I may make my submissions, I'll clarify. My lord, the FIR was subsisting.
While the FIR was subsisting, my bank account was declared as fraud. It's a subsequent act. Hence, my lord, I've preferred this writ petition because the FIR is dated 18th August 2023, writ petition filed in 2024, division bench judgment, my lord. It's already in the affidavit in reply. It's my pleadings case that judgment will not have any bearing. Be that as it may, my lord, today it's for extension of interim order. Affidavit in reply already served. May I file my affidavit in reply?
The matter is listed as to be mentioned for extension of the interim. Learned counsel for the respondent raised objection for extension of the interim order. He further submits that in view of the judgment passed by the Honorable Division Bench in other matter, in this matter also the petition is required to implead the CBI as party respondent. Learned counsel for the petitioner dispute the contention raised by the petitioner and submit that the petitioner has not prayed for quashing of the FIR. The petitioner has challenged the so-called notice wherein the bank has intending to declare the petitioner account as fraud.
Yes.
Full stop. At the learned counsel for the respective parties, this court finds that the petitioner already enjoying the interim order. According interim orders for the last several dates. Accordingly, interim order is extended till 4th of February 2026 or until further order. Let the matter remain in the list. The affidavit in reply filed by the petitioner be kept in the record.
I'm grateful.
I'm grateful. Both karne na?
Both 2 and 3.
Yes.
No,
This petition, my lord, concerns the reporting of loss, my lord, in the civil account. My lord, this has really, my lord, come in the way of our carrying on business. So, my lord, we have assailed this. Now, my lord, so far as this is concerned, your lordship had initially given my learned friends an opportunity to file, my lord, an affidavit in the form of a report. My lord, the report has been filed, but before I take your lordship through the report and make my submissions in this regard, my lord, may I just show your lordship, my lord, some essential features of, my lord, the application first.
I have an application for addition of party.
Is in this matter?
Yes, sir, I will read out and not say anything. If I find it affects my client, then I'll press. Otherwise, I'll keep quiet and not disturb anybody.
Well, lord, first of all, my lord, if your lordship, my lord, sees what the reliefs are, the reliefs are only, my lord, with regard to the declaration of loss in a particular account of Kejriwal mining. Now, it is not my learned friend's case, my lord, that he is in any manner concerned with Kejriwal mining. So, my lord, it cannot in any manner affect him. My lord, there is internecine disputes, my lord, between the parties. Two brothers have been fighting each other in diverse forums. So, my learned friend thought it in the fitness of things to come and file an application even this.
See Kejriwal mining of my learned friends client without doing something, we find addition of party because twice we have caught them trying to sell off shares in my company and my assets for in a settlement.
Not related to Delhi. Not related to Delhi.
Not- So will we come? We quietly watch. If we find our assets are being given in the form of settlement, we intervene. Otherwise, we keep quiet.
Okay.
Very well, my lord. If your lordship will kindly take up the prayers once.
Which one?
No copy of the report.
Reserve Bank of India? No, but তুমি কি Reserve Bank এর হয়ে? হ্যাঁ।
You are appearing for whom? Okay. What report you want? Of the bank report? Filed by the bank. Serve the purpose.
My lord,
yes.
Sibyl is under, my lord. Please come and have a look at, my lord, the prayers, my lord, of the writ petition at page 22. My lord, please see, my lord, that we are primarily concerned with, my lord, the classification of the account of, my lord, the petitioner, that is Kejriwal mining. My lord, a loss or fraud account. Now, my lord, the word fraud has not been, my lord, mentioned my lord, in the civil report. My lord, the word fraud was, however, my lord, included in a, my lord, 2015 communication, my lord, that was made. That is why, my lord, we are not very sure about what is the status. So, my lord, it has been, my lord, to remove the loss or fraud classification of the account, that, my lord, this petition has been filed. Now, my lord, if your lordship will have a look at, my lord, what is the classification with which we are concerned. My lord, please have a look at, my lord. We lost fraud classification to kothay chilo. Well, please see page 48 once.
348.
Only 48. Well, this is the copy of the civil report. Well, it is unfortunately not extremely legible, but my lord, if your lordship sees, my lord, there are, my lord, there is, my lord, a portion at the top of the page which is marked 10. Civil rank. Well, this is, my lord, the civil rank. Well, 10 is, my lord, a very poor rank. Worst. It is the worst rank. So, my lord, I have been ranked under, my lord, with the my lord, classification 10. Now, my lord, if your lordship will now please have a look at, my lord, now, my lord, the portion at, my lord, page 48, my lord, which is, my lord, blackened out. It talks about current exposure.
Page 48.
48, my lord, there's a portion, the fourth blackened portion. But if your lordship, I don't know, my lord, whether it's very illegible. It's got talks about current exposure.
Current exposure, yes.
Yes. Now, my lord, current exposure, if your lordship sees now, but if your lordship will find that, my lord, the exposures are, my lord, listed under the serial number 5. For example, my lord, Sway Equipment, my lord, exposure is given, Indian Overseas Bank exposure is given, ICICI Bank exposure is given, Amcol exposure is given, and then the others. My lord, the others exposure is, my lord, shown here as 5711.0. Now, my lord, the bank that we are concerned with presently, which has purportedly reported, my lord, my account is a fraud or a loss account to the civil, is Indian Bank. So, my lord, Indian Bank is, my lord, included within this figure.
It is something else and the loss is something else.
Yes, my lord, it is, my lord, they have mentioned in their report, my lord, as fraud.
If you go by the fraud, then the different procedures are there.
Yes, but my lord, what they have done, they have, my lord, mentioned in a letter that my account is a fraud account. But, my lord, the civil reflection is of loss, which is equally bad because, my lord, it really comes in the way of my carrying on business.
Where is the fraud declared?
Now, my lord, fraud is in their letter and, my lord, even in their report that they have, my lord, now relied upon. My lord, there is a letter that was written by them on the 15th of, in 2015. My lord, that is at page 28.
28.
Yes, my lord. My lord, this is, my lord, a communication of 16th March 2015.
Yes.
My lord, which is what they have, my lord, reproduced even in their report. Now, if your lordship sees, my lord, at the bottom of the page, page 28, bank has declared fraud in this account and has also initiated criminal action against erring borrowers or guarantor. Police or CBI complaint has been filed. Bank is compromising only its civil liability and not the criminal liability. So, as per extant guidelines, the investigating agency, CBI police, will be properly informed about the terms of the compromise approved by the bank. Well, this is a OTS letter. Please see the heading, Approval of Compromise Offer. Now, my lord, while saying that, my lord, this is a compromise offer, this is being accepted, my lord, it has also gone on to say that, my lord, there is fraud in the account. Now, my lord, so far as the account is concerned, if your lordship sees, my lord, this is in respect of, my lord, Parijat Vyapar, which is now, my lord, which is Kejriwal Mine. Now known as Kejriwal Mine. Now, my lord, here, if your lordship now sees the next page, please see page 29 at clause 9. My lord, this is the reason for which, my lord, they purport to declare this as fraud. the fake title deed of the property submitted by the borrower shall not be returned even after receipt of the entire compromised sum. After closure of the account, this fake title deed will be kept in safe custody till they are handed over to the investigating agency on their demand. So the allegation was that the security offered in the form of title deeds, they were fake documents. Now, so far as this is concerned, two things that run really contrary to what they have said with regard to fraud is number one, they are compromising the account, but they say we maintain it's a fraud account. Number two, they say it's fraud account for the reason that there are fake documents that are submitted. This was in 2015. Now, if your lordship will see one document in this regard, please have a look at and a letter written by an advocate for the bank at page 30. Assistant General Manager at page 30. This is the letter of 7 September 2022. So, since 15, they are maintaining that this is a fraud account. In 2022, they write a letter. And this letter is signed by the Assistant General Manager of the bank. It says, subject verification of title deed number such and such. It says, with reference to the above, we would like to state that the verification of genuineness of your title deed number such and such was done by our empaneled advocate, Shri such and such. It is found that the title deed held by the bank is genuine. So, that problem is resolved. Now, in 2022, for the first time, we find that there's a reflection in the account that it is a loss account. Now, please come back to page 48 once again. Now, your lordship has seen at page 48 that the exposure, others is only 5,710. We are concerned with the Indian Bank. Indian Bank is not SREI, not Indian Overseas Bank, not ICICI, not HON'BLE. So
where from your page 48?
Page 48, your lordship has seen first by the exposures.
Exposures.
Indian Bank has no exposure. It is coming within the heading others or under the heading others. 5,710. 5,711. This is only 5,000. Under 5 year lordship is found.
In the middle.
There's a number
Achha,
5 in the
okay.
middle of the page. Under that, the 4 exposures are mentioned.
Indian Overseas 9.5.
Yes, we are concerned with the Indian Bank.
Indian Bank
Indian Bank is under others.
Others, yes.
And others is only 5,711 rupees. I'm talking from the civil report. This is the civil report.
Yes.
Now, if your lordship will please have a look at page 52. Now, if your lordship sees at the middle of the page, there's this heading, delinquent credit facilities.
Yes.
Now, please see, there are 2 accounts mentioned under this. Indian Bank cash credit account ending with the numbers 1165. And then just after that, there's another account ending with the numbers 9927.
Yes.
Now, both of them have been reported as loss.
Correct.
Now, so far as this loss account is concerned, this is what really concerns me at this moment. Now, I don't understand how it can be loss account when even according to them, only 5,710 is the total exposure. 57. Now, please come to page 57.
So, what is the criteria for declaring the account as a loss?
Well, I would imagine that it is not recoverable. Amount is not recoverable, or the securities are insufficient, or that the amount could not be recovered in spite of best efforts. It has to be one of these. I shall show you, lordship, what is the criteria. But please see, what is the report first. At page 57, at the top of the page, your lordship will find.
Page 57?
Yes, it's a part of the same report.
Yes.
Well, at the top left hand, your lordship will find at the first black portion, Indian Bank.
Yes.
Well, if your lordship comes to the right of the same, the row, your lordship will find it says credit account number ending with 1165, loss. Then will find at the right hand side, dispute date 5th August 2025. Dispute remark, certain information for this account has been disputed by the entity. What it is, we do not know. Then your lordship will find the sanctioned amount. Just after that, loan information sanctioned amount was 4 crores 80 lakhs. Drawing power is 0. Installment amount is blank. Tenure is 0. Next, my lord, sanction date was 29th August 2009. Outstanding balance 5,710. So, my lord, this is the total outstanding even according to CIBIL.
Yes.
Now, my lord, if your lordship comes down the page, there is another portion in blank, my lord, against which the account number mentions 9927. Similarly, it says loss. Then, my lord, will find that, my lord, the dispute date is 5th August 2025. Dispute remarks certain information for this account has been disputed by the entity. My lord, what this is again, we do not know. Then, my lord, kindly see just under that on the right-hand column, right hand, my lord, in both, my lord, the portion just after the, my lord, 2 rows, status suit filed open, not willful defaulter. Now, my lord, if I am not willful defaulter, then, my lord, the question is, how is it I'm a fraud account or a loss account? My learned friends have in their report said I'm a fraud account. Now, my lord, please see the loan information in respect of this account.
Long term.
My lord, this is a long-term loan, and my lord, here, my lord, the sanctioned amount was 1 crore. The drawing power is 0. Then, my lord, the sanctioning date is 27 November 2009. Outstanding balance is 1 rupee.
Where page 58?
57. 57, my lord, the second, my lord, portion in black.
Yes, 1 crore. Drawing power 0.
Drawing power 0. Then, my lord, under that, outstanding balance 1.
So, why the drawing power 0?
Well, because the account is not operating anymore.
And
settled.
Sanction amount 1 crore.
1 crore, everything paid off.
Acha, paid off.
Balance is 1 rupee. Now, my lord, if your lordship now sees, my lord, the next page.
So, if the balance is total, if there is no balance, how the account run, then it is to be closed. Account is to
My
be
lord,
closed.
we have paid off. The account is settled. My lord, that settlement is recorded. What had happened is, my lord, there's an OTS. Under the OTS, my lord, there were some payments to be made. My lord, the payments were, my lord, belated. My lord, there is a provision in the OTS for charging interest. Ultimately, my lord, they declare us to be willful defaulters. We come to court saying that how can we be willful defaulters? We've been paying. My lord, the division bench directs us to make payment of whatever is the balance amount under, my lord, the settlement account. That is paid. It is recorded. My lord, there is a claim for interest. My lord, we admit interest in terms of the provisions of the OTS, my lord's settlement letter at 1 crore 46. We want to pay that. They do not accept it. But the entire principal is paid, recorded, and the willful default tag is removed. Well, that is the status of the account even as per the division bench order. Now, my lord, here, just before I show your lordship the division bench order, please have a look at, my lord, just one more page. Yes, my lord, 57, same page 57. My lord, please see when they first start reporting the account as a loss account. Well, at the bottom of the page, your lordship will find that there are some, my lord, black dots.
Yes.
Now, my lord, at the extreme left-hand side, your lordship will find year 2022. And, my lord, then your lordship will come to August. It's mentioned L.
Yes. Loss.
So, my lord, from August 2022, despite the fact that, my lord, the balance is 5,710 rupee and 1 rupee in respective accounts, they start mentioning this to be a loss account. So, my lord, that is when, my lord, for the first time, this is, my lord, mentioned as loss. Now, my lord, please have a look at the orders that were passed with regard to, my lord, the settlement and, my lord, with regard to the payments that have been made. Now, my lord, your lordship has already seen the 2015 letter. This is the OTS letter of 16th March 2015, which I, my lord, showed your lordship at page 31. No, OTS letter to go at page 28. My lord, please once again have a look at this letter at page 28.
Page
28, my lord.
Yes.
Well, this is the OTS settlement. Well, it says, this has reference to your proposal that is such and such for compromise settlement with regard to loan outstanding of rupees 4 crores 11 lakhs. In the ledger balance in the accounts, that is CC account is 3 crores 73 lakhs 27,386 and term loan account is 37 lakhs 75,340. Well, the amount of acceptance is 4 crores 11 lakhs 2,726. Payment term is down payment of 5%. Balance payment, my lord, is provided, my lord, in equated installments. And then your lordship will see that, my lord, so far as this is concerned, my lord, there's provision. My lord, it says 19 equated installments, then first installment within such and such, 18 equated, then interest.
Yeah, this is
will be-
whatever it may
Yes,
be.
my lord, then it provides for interest. Now, my lord,
So
after
whether
this,
in terms of this, you have already paid.
yes, now, my lord, that I want to show your lordship. My lord, there's an order of the division bench of this honorable court at page 31. My lord, this followed, my lord, the declaration of the account as willful default. This is an appeal from a judgment and order made by a learned single judge on 26 June 2020 in writ application. By the said order, the review committee was directed to review the order dated 3rd July 2019 of the Willful Defaulter Identification Committee, declaring the appellants as willful defaulters. By its order dated 28 July 2020, the bench admitting the appeal inter alia directed the appellants would have the option of depositing rupees 64 lakhs with the respondent bank. The bank was to rectify its records by inserting against the words willful defaulter sub judice before the High Court at Calcutta. Upon rupees 64 lakhs being deposited, the respondent bank would not take any further step with regard to declaration of the appellants as willful defaulters. We are told that this amount has been duly deposited by the appellants. The declaration of account as non-performing is serious enough for a borrower. More drastic and damaging is the declaration that he is a willful defaulter. The declaration by the lending institution immediately affects the business of the borrower, disqualifies him from availing of a loan from other financial institutions, and in general carries a very bad reputation of him in the business circle. Therefore, this declaration should only be made by a lending institution most cautiously, only if the facts and circumstances so permit. A borrower may be a defaulter by circumstance. His business may not be running profitably enough to enable him to pay the loan. Hence, he may be in default. This default is not willful. Willful defaulter, in our opinion, signifies a culpable or guilty state of mind, whereby, in spite of ability, the borrower does not make payment of his outstanding dues to the financial institutions intentionally and remains in default, or misapplies or misappropriates the loan fund, knowing fully well that his action will result in default of its repayment. On 16th March 2015, this letter I have showed your lordship, the bank by a letter approved a compromise offer by the appellants. The accepted amount was 4 crores 11 lakhs 2,726, which has been described as one-time settlement. The settled amount was to be liquidated by a down payment of 5% amounting to 20 lakhs 55,136 and the balance by equated monthly installments. On 27th March 2019, Willful Default Identification Committee decided to issue a show cause notice to the appellants for declaring them as willful defaulter, and apparently, as per the Master Circular dated 1st July 2013 of the Reserve Bank of India. On 6th April, a show cause notice was served. Then, I'll skip over a few parts. Please come to the bottom of page 33. Or, please come to page 34, third paragraph. In view of our findings above, the decision of the respondent bank dated 18 January 2020 declaring the appellant as willful defaulters is set aside. Declaration of the appellants as willful defaulters or proposed willful defaulters has to be forthwith erased completely from the records of the respondent bank. We direct the re-adjudication of the show cause notice by the WBDSU without such declaration upon considering the reply filed by the appellants upon hearing them, etc. And then, my lord, 146 at 34, at page 34, top your lordship will find, at the second sentence, on the contrary, they have shown their bona fide by depositing 64 lakhs with the bank, further to our said interim order. And, my lord, also one more important part which I should have showed your lordship, page 33, please see the third paragraph. With regard to the first ground taken, which is considered by us to be most important, it does appear from a supplementary affidavit prepared and filed by the appellants that from 19 January 2015 till 11th August 2020, substantial payments aggregating 4 crores 11 lakhs 71,726 was made, and only interest amount of 1 crore 46 lakhs 98,630 was outstanding. Furthermore, submitted that his clients were willing to repay whatever outstanding the respondents on such terms that the court may set fit. So, my lord, we were prepared to even pay this interest amount. So, everything paid. They did not accept the interest amount because, my lord, they have made a claim for further interest.
So, now what remains?
My lord, nothing remains. But, my lord, they have identified my account as a loss account. Now, my lord, here, my learned friend's justification is, my lord, we had said that, my lord, now the law is very clearly set forth. My lord, before you proceed to declare any account as fraud account or a loss account, you must give me an opportunity of hearing.
Fraud is set aside.
No,
Whether now, as per
that is
page-
the
page-
problem. Now,
As per
let's-
the page 34, as per the, in view of the findings above, the decision of the respondent bank dated 18 January 2020 declaring the appellant as willful defaulter is set aside. The declaration of the appellant as willful defaulter, proposed willful defaulter, has to be forthwith erased. We direct the re-adjudication. So whether the re-adjudication was done?
No, they have not taken any step.
Then
Now, my lord, today, my lord, when
this
your-
is the in the appeal at January 2020, and you in the present application, that is letter of the 2015.
because my lord, 2022, my lord, they first declare my account as loss account.
Ah.
Now, my lord, I am making representations to them. My lord, this my lord, civil representation continues. Now, my lord, my learned friends are saying that my lord, they are under an obligation to make a reporting of loss to civil. My lord, I ask myself the question: where is the loss reported in the civil records? Because both accounts have been, my lord, settled. In one, they show an outstanding balance of 5,000 rupees, 5,710 to be precise. In one, my lord, 1 rupee. Now, my lord, in spite of that, they insist on continuing, my lord, with this persecution. And, my lord, particularly after, my lord, the willful default tag has been removed, the court has said that, my lord, this is serious civil consequences. You cannot, my lord, visit a person with these consequences. Now, my lord, in the affidavit that my learned friends filed, my lord, please see, my lord, what they are trying to say now. Now, my lord, the order of the High Court is, my lord, the High Court order is dated, my lord, August 2022.
Yes.
Now, my lord, August 2022, your lordship sees, they now report it as a loss account. Well, I
That's
showed
why-
you, lordship, the black dots.
No, that's why I'm contending. When you file this is a 25 writ application.
Yes.
So which order your challenge here?
No, my lord, I am, my lord, challenging, my lord, now, my lord, the reflection of the account as a, my lord, loss account. I say that it can't go on
That is to
forever.
be deleted.
Yes. Now, my lord, when your lordships, my lord, call upon my learned friends to explain the situation, they file a, my lord, report in the form of an affidavit. My lord, please see,
So
my
what
lord,
the
what
bank
they...
says?
Yes, my lord, please see, my lord, that report now. My lord, paragraph 4. I say that Kejriwal Mining Private Limited petitioner number 1 company, earlier known as Parijat, had availed of financial assistance from erstwhile Allahabad Bank, now known as Indian Bank. Then paragraph 5. Directors of Kejriwal Mining, earlier known as Parijat Vyapar, are also major stakeholders in respect of loan account of Pioneer Barter Private Limited. Both these accounts have been declared as fraud account under the then RBI Master Directions on Fraud Classification and Reporting. Now, my lord, they are trying to club, my lord, other accounts with the account of Kejriwal Mining. And, my lord, in an attempt to justify that Kejriwal Mining account should be declared a fraud account, and, my lord, now, my lord, I get rid of the willful default tag, they immediately report it as a loss account. Why loss? There's no reflection. And, my lord, in this, they are now, my lord, trying to say this is a fraud account, so, my lord, the classification should continue. Now, my lord, how are they saying this? My lord, fraud, because, my lord, the stakeholders, directors are also stakeholders in other accounts which have been declared fraud. My lord, declaration of fraud, as your lordship knows, my lord, must follow a particular norm or set of guidelines. Nothing happens.
So that's why now paragraph 6.
Yes.
There is another loan account in the name of so and so, wherein the director so and so.
Declared as fraud. My lord, where is, my lord, the show cause notice? Where is the opportunity? Where is the personal hearing? They don't say it. Unilaterally declared as fraud. And, my lord, in any event, Kejriwal Mining is a company. My lord, it has paid its debts. There is nothing outstanding. If anything is outstanding, my lord, that is subject matter of adjudication. The civil account says, my lord, there is outstanding balance of 1 rupee and 5,710 rupees. Can you now say that I have declared your brother account, sister account, parent account, daughter account as a fraud account, and hence I will not, my lord, let you be. I will not allow you to do business. Well, that is exactly what is happening. And now, so far as the classification of these, my lord, accounts as fraud account is concerned, they don't even say that they followed the guidelines. Now, my lord, what is my learned friend's contention? If your lordship sees, it's surprising. Your lordship has seen the OTS settlement letter of 2015. There they say we are settling, but we will not relieve you of the fraud declaration. Ultimately, the bank says that the title deeds are genuine. Now, my lord, what they're saying is that so far as the fraud declaration is concerned, we were not required to follow the guidelines because the guidelines with regard to fraud declaration came in 2016. You have been declared fraud in 2015. Now, my lord, with the greatest respect, my lord, the guidelines are only amplification of the rules of natural justice. So, my lord, today you say that because I declared you a fraud in 2015 on the basis of, my lord, fraudulent supply of, my lord, title deeds, I will continue with the declaration, although, my lord, subsequently the assistant general manager said that the title deeds were genuine, and, my lord, simpliciter saying that it preceded 2016. My lord, please see, my lord, what is said. My lord, here, my lord, continuously, my lord, paragraph 8, 2013, bank had lodged a complaint for cheating, misappropriation funds of against Siddharth Kejriwal, Mahesh Kejriwal. Is there any, my lord, finding against them? Have they been, my lord, ultimately, my lord, sentenced? A company is a separate juristic entity. My lord, yes, it functions through shareholders and directors. You have not said that, my lord, their accounts are, my lord, ultimately declared fraud. And what is my learned friend's, my lord, contention in the affidavit, in the report? He says that we are obliged under circulars, my lord, a copy of which has been made over to us, to report matters to the CIBIL. Now, my lord, what has been reported to the CIBIL? The fact that there's a settlement. 2022 August, my lord, willful default tag is removed. Entire dues have been paid, recorded by the High Court in its division bench, in the division bench order. And, my lord, ultimately, they then say it's a loss account.
You see 5,000. Paragraph 11, see that paragraph?
Yes.
11?
My lord, please see paragraph 11. In spite of accepting compromise offer and making some part payments against loan accounts which are the subject matter of settlement, petitioners failed to adhere to terms of payment of compromise amount, due to which compromise settlement was treated as withdrawn as per the terms of approval. Very well, withdrawn. My lord, does it make the account a fraud account? My lord, your reporting is, my lord, the outstanding balance is, my lord, this. Now, my lord, whether any further amount is due to you on account of interest.
That's why now the only two things is to be considered: how the account is to be treated as a loss account.
That's right.
And under what circumstances your account has been declared.
That's right.
As a loss. These are the two things.
That's right.
Let the give answer.
Yes, my lord, let my learned friends, my lord, address your lordships on that. But I should show the reply.
Last occasion I had addressed your lordship in detail, and may I submit lordship? The fact that today lordship what has been submitted is just to confuse your lordship of what the moot issue is. The reporting of civil, willful defaulter and fraud are three completely distinct matters. Civil reporting is respect of everyone. Even I bear a civil score, and civil score is something which is looked into by the other concerned entities or authorities will be advancing finance for the purpose of ascertaining whether a person is, what is the repayment history. Basically, civil concerns the history of loan defaults, repayment, settlement, everything. It is a much more detailed procedure which is under the Act, and now there are guidelines of the RBI under which there are certain disclosures which are mandatorily to be made by the bank. First of all, lordship, the settlement was not adhered to. Lordship, till today's date, what is the outstanding has been categorically mentioned in paragraph 22 of my report, which was also supplied to them before filing this writ petition. And that letter was not filed with the writ petition, lordship. That letter is also appearing at page 32. This is the total outstanding against the loan accounts where of Kejriwal Mining, as well as the other accounts where the directors of Kejriwal Mining are the directors of the said companies and borrowers of the bank, lordship. So the total, lordship, will kindly take up page 34 of the report. The letter starts from 32. This was not filed with the writ petition, lordship. This was served upon them. A reply letter dated 14/8/2025, after receiving their dispute with regard to the civil reporting. This letter was supplied to the petitioners by the bank, where the entire details of their representation was dealt with. The bank has indicated in detail that what is the outstanding, and it is total dues concerning the account of Kejriwal Mining, as well as the other accounts where the directors are the borrowers, is around 72 crores 16 lakh 29,585 and odd, Lordship. This is the outstanding. Lordship, the order of willful defaulter, the Honorable Division Bench matter, Lordship, there it has not been recorded that the settlement was binding on the bank. Neither has it been recorded that they have paid in terms of the settlement. All that the Honorable Court did was initially the willful, the Identifications Committee's report was challenged before this Honorable Court. The learned single judge held that the review committee was the appropriate forum, and the otherwise he had upheld the order of the Identification Committee, and was carried in appeal before the division bench. There, the Honorable Division Bench made an interim arrangement whereby the Honorable Court had directed them to deposit a certain amount of money, which was to the tune of 64 lakh rupees. That was deposited, and the Honorable Court has sought a calculation report from the bank that what was the calculation in respect of the OTS, what was the outstanding. That was bank had provided that, but in that self-same report, bank has also provided what was the total dues or claims of the bank as on that date, Lordship. So in that order, if I may place in details in that order, Lordship, if your Lordship reads the entire order holistically, the Honorable Court has not said that it is settled. Had the Honorable Court been minded that the loan account was settled, then in that event, the Honorable Court would not have directed the bank to consider the issue of willful defaulter afresh. So, Lordship, that willful defaulter classification, that is a completely separate aspect. Today's date, Lordship, whether the borrower is or the petitioner before your Lordship is aware of his outstanding, Lordship will kindly take up one email which is annexed at page 38
of the petition
of the report, Lordships.
38
of the report.
Yes.
Lordship will find that he has mentioned, the petitioner mentions that I am writing with reference to non-performing accounts under the following 4 account numbers. He mentions, and here there 2 account numbers are of Kejriwal Mining, Lordship can find in the first one. Since the beginning, I have been consistently trying to settle the accounts amicably and in good faith. Despite my sincere efforts, certain formalities and procedural issues have remained unresolved. We had earlier interacted with Mr. This and This regarding this matter, and based on those discussions, I now wish to make this forward to its logical conclusion. I sincerely propose to personally meet you in Chennai to discuss and finalize the closure of the said accounts. So the submission today, what has been made, or rather what I understood of, is that though compromise was adhered to, there was no compromise. The compromise had failed.
What is the date? July 25.
Yeah, Lordship will sees that, yes, it is of 27th June 2025, Lordship. 27th June, he writes to the bank that there are outstanding against his loan accounts. And he admits that Kejriwal Mining is one of them. Lordship, I can place, today, Lordship, we are pressed for time. I want to place the guidelines, the RBI circular, Lordship. I had the occasion of placing it on the last occasion. Lordship, what is to be reported, that this is an obligation cast on the bank, that what is to be reported, and I most respectfully, Lordship, it is also in respect of close accounts, loss account, everything, because it is this credit score is assigned to every entity with respect to their credit history. And the bank is under an obligation to report certain things, and the bank has is complying with the same, and bank has given an explanation, which is the letter dated.
What is the status of this outstanding today till today?
Lordship, it is outstanding.
They are not paid.
No, they have not paid. This is the, Lordship, this writ petition, Lordship, most respectfully, involves questions which will require adjudication on evidence, because I as the bank, I say this is my outstanding. Today there are criminal cases. Lordship will kindly see annexure A1. This is the charge sheet, Lordship. There is a CBI investigation which is pending. Lordship will find the name of Lordship at page 15, Mahesh Kumar Kejriwal. He is one of the petitioners here. Lordship, there is the FIR is there, and the entire records will reveal that they are defaulters. They are still continuing with the default, and today, as on the date of the letter, that is 14/8/2025, the bank says that the bank is entitled to a sum of around 72 crores from the petitioners.
Yes.
And
what is the reply to the trend? They are not filed reply. Taken the exception to the report.
Lordship, they have not taken out an exception to the report. I know they have. Sorry, Lordship, my mistake. Yes, they have filed a reply to the report, but not to the letter. Letter which was initially served, they directly approached this honorable court. There is a reply. This is the reply.
Yes.
Yes, and with Lordship has also fixed this matter on 16th. The 2 dates are fixed, today and 16th. Lordship, may I come back on 16th and place this relevant circulars?
And the learned counsel for the parties. Find that the matter is already fixed on 16 January 2026 at 3 p.m. Let the matter appear on 16 January 3 p.m.
My lord, our item is number 5. Can you please hear this matter? It won't take more than 15 minutes, my lord. They have been violating your order for more than 1 year, and they have been given 3 opportunities to file affidavit in compliance, but they didn't file affidavit in compliance on all the 3 occasions.
You are appearing for whom?
I am plaintiff's son. I am plaintiff's son, my lord. I am appearing for the plaintiff, my lord. My lord, these contemners 1 to 6 in case of Abdul Rizwan versus Abdul Hadi versus what is his name? Muhammad Rizwan and others. In this case, what happened is, my lord, on in the last year in 2024, on 25th September of 2024, you passed an order, final injunction order, which you passed, and there were 4 directions in that order. The first direction, which was like to pay monthly maintenance to plaintiff 1 and plaintiff 2, and the second direction was to deposit the 80 lakh with the registrar of High Court, and the direction 3 was not to sell the properties during the period of injunction. But yet these contemners 1 to 6 sold out the properties. Direction 4, my lord. Submission of quarterly accounts, which also they didn't submit. My lord, this was a family partition case, my lord. This is an ancestral business, and therefore we filed a contempt application. And these contemners 1 to 6 were given 3 opportunities to file the affidavit in compliance, but on none of the occasions they failed to file affidavit in compliance. On all the occasions, they are just making mockery of the High Court. They are making, if this continues, my lord, if they get away this way, then the order of High Court will lose its value. The order will be reduced to merely a piece of paper, having no value. My lord, something has to be done. It cannot be going on like this. At the end of the day, we plaintiffs are suffering, my lord. And these lawyers, they're backing themselves. They're backing, and they are arguing that their senior is not there. They're asking for time. They're asking for interruptions always.
This is the last order. This is the last order.
My lord, my counsel will present.
My lord, this is the last. My lord.
Yes.
And my lord, these contemners were also.
Who has not filed the affidavit in opposition?
1 to 6.
1 to 6. All affidavits they exchange, my lord. 7 to 13, they have exchanged, my lord.
7 to 13, they file their.
My lord, they have exchanged, my lord. 1 to 6, my lord, they are intentionally, willingly, and they are not doing anything, my lord.
5 and 6.
Lordship,
My
I
lord, I
They are the
appear on
defendant
behalf
number 2
of
to
my
6.
lord contender number 13.
Yes, you are appearing for?
He is appearing.
13, my lord.
No, I am appearing. I am asking with regard to 1 to 5 and 6. Who is appearing?
1 to 6.
6 I am appearing for.
Yes. Let the warrant be so.
Yes.
My lord, they are present.
In spite of this, yes.
My lord, they are present.
Where is they are present?
My lord, if my,
Where they are present?
my lord, they are outside.
Where is the affidavit?
My lord, they have not filed.
Yes, I am asking one question to the other one advocate. Where is the affidavit? Where is the persons 135 and
Lord, they
1
are
to
coming
6?
before filing our affidavit. We wanted to approach the persons who have purchased land from us.
I don't want where is your affidavit? I am fixing tomorrow. If affidavit is not there, then you have to go to the custody. This is not a playground. Where is your affidavit? Where is the contemner 1 to 5 and 6? 1 to 3 4 5 6?
They are present.
Where they are present?
My lord, they are appearing.
Where is their affidavit?
But they were directed to file by 10th of November, my lord.
Yes.
That was the last chance, my lord.
3 occasions they have failed to file the
My lord, I cannot understand. He is just a complainant. How he is appearing? I don't know.
Just
My lord, I'm telling and
advocate or you're withdrawing the case.
my lord, I'm telling unconscionable.
Saying the pity to
My lord, I am telling unconscionable, my lord. Please.
Once you are appearing, why you are allowing the party to argue the matter before the court?
No, my lord.
Then
Lord.
you all senior persons, you don't
My
know
lord.
the decorum of the court.
He has a heart surgery, my lord. He
My-
is my father.
So why you are engaged?
No, my lord, I'm petition plaintiff, my lord.
Appearing in person.
My colleague got stuck in some other matters, my lord. Due to that reason, my lord. Mr.
He is also appearing in robe.
Mr. Rupa Ghosh is there, my lord. He got stuck in some other matters, my lord.
What is you are appearing in person here?
My lord.
So why you are with the neckband?
My lord, may I? Subject.
The court will advise you.
No,
if you are appearing in person, what is to be done?
No, my lord, I'm going
You
out.
are appearing for who are you?
I am the petitioner plaintiff.
I am the only one.
Only one, my lord.
You are the petitioner.
Yes, my lord.
You are appearing in person.
My lord.
So, if your matter is there, why you are with the rope?
My lord.
Why you are with the rope with the
my
jaw
lord,
and with the
my lord, since
neck?
my counsel got stuck by due to that reason, I'm telling an apology, my lord.
So, if your counsel is not there, why your son is so crying here?
I'm giving you the reason, my lord.
Please.
Contempt, my lord.
Yes, when you file the affidavit.
Kindly fix the matter tomorrow. I'm led by Mr. Arindam Banerjee.
I don't know anything. Who will be appearing? I am taking them to custody. Let them go. You will file the affidavit. I will release them. That is the only thing I can do in the content matter. I am taking into custody. Where is the police person? Call the police person. Let them go to the jail. Let them remain. When you file the affidavit, I will release them.
Kindly give 1 week.
Let your senior will remain in the other court.
My lord, kindly give 1 week's time, my lord. 1 week, my lord.
In spite of the direction passed by this court, the respondents number 1 to 6 failed to file the affidavit in opposition. Learned counsel for the respondent number 1 to 6 prays for a week time to file affidavit in opposition. Full stop. Let the affidavit in opposition filed by by 21st of January 2026 after serving the copy to the learned counsel for the petitioner subject to payment of cost of rupees 30,000 60,000 10,000 each to the state legal service authority. Full stop. If the cost is paid, the affidavit will be accepted, failing which the affidavit will not be taken on record. List the matter. Full stop. If the affidavit is filed, the petitioners are at liberty to file reply within a week. List the matter on 3rd of February 2026.
I'm telling unconscionable.
Hello. Hello.